The time is now 12:36 p.m. The House Committee on Criminal Jurisprudence will come to order. The clerk will call the roll.
Chair Moody,
Present.
Vice Chair Cook,
Here.
Representative Bajani,
Here.
Representative Bowers, Representative Darby, Representative Harrison, Representative Leach, Representative Christina Morales, Representative Schatzline.
Here. The quorum is present. Some housekeeping matters first. I apologize for those of you who've been waiting. The Committee on House Administration has approved a process for the electronic submission and posting of public comments for each item on today's agenda. The public comments submitted through the portal will be posted on the Electronic Legislative Information Systems TLIS and TLO, as well as on the House website. At the conclusion of today's hearing, directions of how to submit public comments on the portal can be found on the meeting notice for this hearing. Today, the committee will hear from invited witnesses only. If you have not filled out a witness affirmation form already, please notify the clerk and we will remedy that problem. Due to capacity constraints in this hearing room, we have 2 overflow rooms set up for anyone present and wanting to watch the live stream of today's proceedings. Those rooms are E1014 and E1026. First and foremost, I want to thank everybody for being here. I apologize for the delay. As anyone who has been following this matter, there is an enormous amount of litigation around this topic. There's an enormous amount of conversation around this topic. And so many of us have been working through that. Did not mean to keep you waiting, and so please accept my apology for that. Today we have an impressive slate of witnesses who I think will surprise everyone and add important dimension to these issues. The most important witness, of course, is Robert Roberson. I'm very disappointed to say I don't believe that will happen today, and I'd like to go over why that is. As many are well aware, there's been a flurry of litigation in the Texas Supreme Court over the weekend. The upshot of that is that a valid legal subpoena for Robert remains in effect. If this committee wanted to take a heavy-handed approach, there are dramatic ways that we could enforce that subpoena. But we didn't issue the subpoena to create a constitutional crisis, and we aren't interested in escalating a division between branches of government. In fact, we have the greatest respect for every other facet of our government, and we want all of them to come together in our purpose here, which is making sure that Robert is heard. There's been a lot of discussion about video conferencing Robert in today. I believe that that'd be perfectly reasonable for most inmate witnesses. But Robert is a person with autism who has significant communication challenges, which was a core issue that impacted him at every stage of our justice system. He's also spent most of the last 2 decades alone, locked away from the modern technology we now take for granted. Video conference is poorly suited for Robert specifically to provide his testimony and would only further the harm he's already suffered. When I thought about the accommodations to be made, I considered his needs as a person with a disability above all other things. I also weighed the fact-finding needs of this committee, the entire purpose of the subpoena. Weighing those with the concerns that were outlined by the Attorney General, our committee simply cannot agree to video conference. That doesn't mean Robert won't testify at all. In the spirit of cooperation, we are in talks with the Attorney General's office right now about ways their position can be addressed while allowing our committee to hear Robert in person. I expect a quick resolution to these discussions, which are ongoing even at this moment, and I will update everyone as soon as those plans are finalized. At this time, I'd like to invite any member of the committee to make any opening remarks. Mr. Vice Chair? No. Chairman Leach.
Thank you, Chairman Moody, and thanks to those of you who are joining us here at the Capitol today, and to my fellow committee members, fellow legislators here in the room, to Texans who are watching on television, and welcome to all of the non-Texans who are tuned in across this country and really all over the world. We are honored to sit in front of you today and, unlike Washington, to show you that government can work, and that Republicans and Democrats can work together, that death penalty supporters and death penalty opponents can work together, that the branches of government, the legislative, the executive, and the judicial branches can work together. When it comes to our fundamental duties as legislators, it's very simple: to protect at all costs the fundamental rights and liberties of the people, most importantly of which is the right to life. And when it comes to the life of a potentially innocent Texan, someone who I have, over the past several weeks, grown from having questions and concerns about to believing he is fully innocent, and was within 20 minutes and 20 steps of being executed by the state of Texas just days ago. If we can't speak up and step up and work together to fix a system that is not broken in and of itself, but that needs fix, that has failed Robert and failed Nikki, then what are we even doing? Today, this hearing, the purpose of this hearing, our purpose for coming together and issuing a subpoena to Mr. Roberson and to convening last week and today and in what is likely a subsequent hearing, is to ask questions and to find the truth, to figure out where the system went wrong, where it failed Nikki, where it failed Mr. Roberson, and to try to fix it, not only in his case, but to make sure that it never happens again. In closing, I'd like to make very clear, members and Mr. Chairman, remind ourselves that when we take our oath of office, we solemnly swear that we will faithfully execute the duties of our office of state representative of our state, the state of Texas, and will, to the best of our ability, preserve, protect, and defend the Constitution and laws of the United States and of the state of Texas. That oath of office I take seriously. I know each of you take seriously. And importantly, that oath of office is the same oath that judicial officers and executive officers take. And the legislative branch today is taking our oath seriously. And I'm honored to be here with our fellow members, and I welcome all the people tuned in to the Texas House of Representatives. Thanks for joining us today.
Chairman Darby.
Thank you, Mr. Chairman. First of all, thanks to the members of the committee for being here today, and thanks to the members of the public and other fellow members of the legislature that are sitting in the third row. I want to build on Vice Chair Leach's comments about our role here today. I'm probably the senior member on the dais this morning. I've been here for a few sessions, and I want to focus the committee and the Texas House on our role and responsibility under our Constitution. Our job is to pass laws, and we do so because we listen to the folks who elected us to come down here and make those decisions, to do the hard work, to focus on an issue, come up with the right policy, and then hopefully we'll pass that policy and it'll make a difference in people's lives. Over the years, certainly during my time here in the legislature, there was a flaw in the system. There was a flaw in the habeas corpus process. There was not a mechanism by which people could appeal to the court to grant relief in a situation where science has changed. Now, they refer to it as junk science, but I would say it's just science has changed. The knowledge has changed. And so we saw a problem. So in 2013, and I think Chair Moody and Chair Leach were members of this committee at the time under Senate Bill 344, this legislature took up this issue. We said, let's create some basis of understanding that would allow relief for people who've been charged and are serving time to address the concern about changing knowledge of science. We did that. We set up steps that the Court of Criminal Appeals could look at. Well, we didn't go far enough. And 2 years later, in 2015, we revisited the issue and we changed it again. We changed the steps. And so what I would like this committee to focus in on, I'm not here to determine guilt or innocence. That's not my job. What I am here to do is, has the legislature failed in properly addressing the tenets by which the Court of Appeals can review these cases. Since the implementation of this law in 2013, there have been 74 applications for writ of habeas corpus based upon junk science. Roughly 25 of those cases were people on death row. None of those cases have been affirmatively reviewed and remanded. None of them. The other approximately 50, 2/3 of those, well, about half of those have been sustained. That science has indeed changed, and so we're going to we'll allow new evidence to support a rehearing or retrial on that case. All of those cases pertain primarily to DNA analysis. We all have gotten caught up with DNA, and we understand that science, and so we recognize that has the ability to determine that the accused didn't do it, but somebody else did. But there's no cases that have been successfully appealed that take a look at the tenets for the shaken baby syndrome that we're dealing with today. Clearly, that body of evidence has changed. And so it's up to this legislative committee to look at the tenets of what's going on here. Has the Court of Appeals taken a position that is inconsistent with the statutory language that we have set out for them to follow? Are they ignoring that and saying, well, yes, it's changed, but it does not determine who the guilt or innocence? That's a level beyond which I originally envisioned in 2013 and 2015. That's a higher level. Is that a level this committee and the legislature wants the Court of Appeals to review these cases? That you actually have to have the scientific facts determine the innocence of the accused? I think not. And in this case, I think so we need to be looking, what I'm looking for with the witnesses is how are we as policymakers to look at the statute that says this is the criteria by which and the lens by which we will review the facts of this case and determine whether or not a new trial should be justified. That's what our business is. That's what our business is, not to determine guilt or innocence. It's not to argue about the death penalty. It's to determine that we as legislators have created hurdles in statute. And is the Court of Appeals following those hurdles in the spirit by which we were intending them to follow? That's what this committee is about. It's not about guilt or innocence. Guilt or innocence will be a byproduct of our hard work. Thank you, Mr. Chairman.
Chairman Darby, thank you very much. Yes, Representative Harrison.
Thank you, Chair. I want to start off by thanking everybody who's taken the time to tune in or come to this incredibly important hearing today. And I also want to start off by thanking every member of the Criminal Jurisprudence Committee for voting on a bipartisan unanimous basis for the issuance of what was admittedly a historic and wholly unprecedented subpoena. I'm grateful for each one of you for taking such a bold action that even though it was historic and without precedent, I firmly believe it was absolutely necessary given the extenuating circumstances in this case. And without wanting to get too philosophical, I do want to remind everybody that in our country and in our state, in the great state of Texas, it is the people who write the laws that govern them. And they do that via their elected representatives in the legislature. So it is incumbent upon us to make sure that the laws that are duly enacted by the legislature are being faithfully adhered to by those who are subject to them. And so for people out there who have concerns, who have raised questions about separation of powers, I want to be unequivocally clear. If you care about the maintenance of the proper functioning of our constitutional system of separation of powers, you should be the loudest supporters and the biggest proponents of what this committee is doing here today. If the House of Representatives cannot exercise legislative oversight to make sure that our laws are not just being faithfully adhered to, but that they are not potentially being so egregiously violated that it may result in the life of a potentially innocent person being taken by the government, then I would posit there may be no matter that could be subject to legitimate legislative oversight. The role of government, ladies and gentlemen, is the protection of life and the protection of our liberties and our freedoms, which do not come from the government, but that are endowed, as our founders knew and codified in our founding documents, in an inalienable fashion, endowed to us by our Creator, and it's the central role of government to protect them. So especially when we are weighing something before us as constitutional officers of the state of Texas, where a man's life literally hangs in the balance, and we are contemplating the government exercising the ultimate and most awesome power that we give a government, and that is to take a life, we cannot get this wrong. And I say that as somebody, ladies and gentlemen, I want the state of Texas to lead the nation in just about everything. But executing potentially innocent people is not one of them. I do not want my children, and I think I can confidently say this for my colleagues on the dais here, I do not want my children to inherit a state where potentially innocent people may have their lives deprived from them by the government. So in closing, I want to just thank not just my colleagues on this committee, but every single member of the Texas House of Representatives who has spoken up and has unified and is making the conscious decision to put aside partisanship and put aside the issues that usually divide us so that we can come together in the pursuit of justice. Thank you, Chair.
Thank you, Representative. Any other members have opening remarks? Yes, Representative Bowers.
Thank you, Mr. Chairman, and I don't have much to say, but I just would like to say thank you to all the members of this committee for every bold and courageous move that was made by those here on the dais as well as those that are out in the audience. There's a higher being that knew that each of us in this room would be here today at this moment and for this time. And so I just want to say thank you all for being here. And it is historic that we are all sitting here and we are going to make some decisions that hopefully will bring positive change to this state. Thank you.
Thank you. Any other members with opening comments? Nope. Okay. Before I begin, I'm going to just let you know who the witnesses are that we'll be hearing from today. I'm going to list them in an order that I intend to call them. I want to be very clear that those things can change with schedules and logistics, but I'll go through that list now. Dr. Philip McGraw, John Grisham, the Honorable Elsa Alcala, Terry Compton, Kate Judson, Don Salzman, Dr. Natalie Montfort, and Gretchen Swine. At this time, the chair calls Dr. Philip McGraw.
Matter which one?
Choice is yours.
All right.
Now, Doctor, we don't probably have the same audio capabilities that you're accustomed to. No disrespect to the House administration. But these microphones are directional, and so want to make sure that we're able to hear you. Before I do turn it over to you for your testimony, I do have to do a little bit of housekeeping. I have you registered as a witness as Philip McGraw, Ph.D. You are here testifying on behalf of yourself, and you're testifying neutrally on the topic being considered today. Is that correct?
That is correct.
All right. Sir, I appreciate you taking the time to be here, and I don't want to belabor the point, so we'll go ahead and turn it over to you to offer your testimony. The members up here may have some questions following up after your testimony, but we look forward to hearing from you. Thank you, sir.
Well, thank you, and let me tell you, it's an honor, a privilege, and a responsibility to be here and address this committee and this important topic. And I'm here today to speak about my experience with Robert Roberson and learning about his case. And I want to talk about what I've done to be able to speak about this. I've reviewed the transcripts and supporting documents from his trial. I've done an intensive forensic interview with him, and I think I am in a position to do that because a lot of my career, decades, have been spent in the legal arena, both civil and criminal. And in terms of my training, so people know, I do have extensive training in clinical psychology and behavioral medicine or medical psychology from the great University of North Texas in their PhD program, and then I completed a postdoctoral fellowship in forensic psychology and spent a lot of time working in the litigation arena for a big part of my professional career. And not to bury the lead, I am 100% convinced that we're facing a miscarriage of justice here. I say that because I do not believe that Mr. Roberson has had due process in this case. I do not believe he has yet enjoyed a fair trial in this matter, and I'll talk about that in detail. I believe that in the United States of America, if we are going to deprive someone of their liberty, that comes at a very high standard. If we are going to deprive someone of their life, that comes at a very high standard. A very high standard of proof, a very high standard of evidence, and when you say beyond a reasonable doubt, that's said so much that I think sometimes it can lose its meaning, and we have to really stop and think what that means. That means that if you have 12 people on a jury, that means that there should be nothing that 12 people can go in a room and reasonably disagree about. And that is a high standard, that there should not be anything that they would go in there and say, well, there's nothing here that we can reasonably disagree about. And I think that when we talk about due process and fair trial, that means that all the evidence, everything that is relevant and pertinent to that trial gets before the trier of fact, whether it be a judge or a jury, and that there's fair representation. And I certainly don't think that standard has been met here, that high standard by which we would deprive someone of their life has been met. And I think that the death penalty actually hangs in the balance here, because if we get this wrong in a case like this, I think that the death penalty
could come under real attack. And there are circumstances where I personally believe that it is appropriate. I think back to James Byrd Jr. on 6/7/98 when he was dragged by King and Brewer in Jasper, Texas. And subsequently, Brewer was executed in 2011 and King was executed in 2019. A third man got life in prison. I look at cases like that and think, you know, there are times where the death penalty just seems appropriate. And it would be I think it would be unfortunate if that was taken off the table. I'm also aware in circumstantial cases how powerful it is for an expert, a physician, for example, to come before a jury and render an opinion. And I've spent so much time in cases and debriefing jurors after a case and know how heavily that weighs on those jurors. And I believe in this case that there was what I would refer to as triad tunnel vision, because there was a shaken baby syndrome that was defined by a triad of symptoms. And those symptoms were subdural hematoma, brain swelling, and retinal hemorrhaging. And that was believed to define the syndrome of shaken baby. And we now know from an evolution of science that that's just simply not the case. That there are a number of other explanations for those syndromes, and that causation has actually been debunked. And as a result, the Daubert test, junk science, it's just been debunked as it's no longer a standard that you can look to in defining that. And I think that once that was looked at as the order of the day, everybody got tunnel vision. And, you know, there's something in psychology known as confirmation bias. And it's been around for a long time. Bacon first talked about it in 1889. And confirmation bias is the tendency for people to make up their mind to something and they close off openness to alternative explanations. They seek and find and hear and process only data that supports their initial belief. And they turn a deaf ear and a blind eye to anything other than what they passionately believe to be the case. And I think we have clear evidence that that's what happened in this case. The decision was this triad of symptoms were written down, and it started with the doctors that were looking at this first, and then it trickled down to investigators and police and went right through the trial process, including Mr. Roberson's defense counsel, including his own counsel. And I've heard and read those that are opposing these efforts say that, well, this really wasn't the crux of this case. It wasn't really what was going on here. And I'm sorry, but I've studied this trial transcript, and it was the crux of this case. It was the center of this case. In one summary that I've looked at, as well, I've read a summary and I've read the actual transcript. I stopped counting at 47 times it was mentioned in the trial transcript. Shaken baby syndrome, shaken baby case, shaken baby syndrome, shaken baby case, triad of symptoms. And let me tell you something that will seem incredibly obvious, but it is not. Juries decide these things on what they see and hear, not on what they don't see and hear. And you would think, well, yeah, but my point is, I've often seen lawyers try to get something into the record and it's kept out, and heard them say, well, we didn't get that in, but the jury knows we had something really powerful, and that's going to stick with them. No, it's not. They decide on what they see and hear, not what they don't see and hear. And there was a massive amount of outcome determinative, exculpatory evidence that was never reviewed. It was never put in front of the jury. It was never heard. And you always hear, and the law is clear, that the burden of proof is on the prosecution. That Mr. Roberson does not have to prove that he didn't do this. The prosecution has to prove that he did. And that's great in theory. But having spent decades in the litigation arena, I can tell you, debriefing juror after juror after juror after juror across decades, they have taught me that they sit back and say, if we're not down here for the reason that the prosecution says we are, somebody needs to explain to me an alternative explanation. Because we know these cases get resolved 100 different ways before we ever get to this point. So if we're not down here for the reasons that they say we are, somebody needs to explain why. They're looking for an alternative explanation. And in this case, oh my gosh, was there an alternative explanation? This child was an ill baby. From 8 days old, the medical record shows this child was not well. The record shows that this baby had 46 doctor or hospital visits in her 23 months and few weeks of life. In the days leading up to her death, the record shows she had 104.5 temperature. The record shows that Robert took her to the doctor twice in the week leading up to her collapse. The record shows that she was prescribed Finnegan on 2 separate days leading up to her death. A black box warning says you do not prescribe this medication to someone under 2 years of age. On the second administration, it was Finnegan with codeine, a double impact that suppresses the respiratory system. We did not hear that this child had severe pneumonia. We did not hear that. And there were scans available to be looked at, and the medical examiner admitted that they were not looked at. And I will provide to the committee, this is a calendar of the 2 years of this child's life, and every red notation is a doctor or hospital visit during her young life. This was a child that was acutely and chronically ill. And when I say that this child had been diagnosed with interstitial pneumonia, on the left is a scan of her lungs, and the pinkish red is non-functional lung tissue, according to the doctors, and I'm telling you just what the report says. I'm not playing physician here. And on the right is a normal lung. This never got in front of a jury. Why? Because it was never looked at. It was never looked at. The medical examiner medical examiner did not review this and said so. This child had collapsed several times when Robert Roberson was not in this child's life. This wasn't the first time this child collapsed and turned blue and had respiratory shutdown. It had happened a number of times when he wasn't around. On this occasion, he was around and took the child to the hospital. So how was this case tried without all of this stuff being put into the record? It's astounding. It's astounding. Even the defense counsel, who did nothing to challenge the evidence, stipulated that this was a shaken baby case. During voir dire, I'm quoting defense counsel, every one of you related to that you had heard the term shaken baby, that it was an act of basically a lack of control of emotion. It's a bad thing, but it's not something that rises to the level of capital murder. His own counsel says this was a shaken baby case. In opening statement, his defense counsel says, this is, however, a shaken baby case. The evidence will show that Nikki did suffer injuries that are totally consistent with those applied by rotational forces, more commonly known as shaken baby syndrome. Now, Robert Roberson was offered plea deal after plea deal after plea deal and never took a plea deal because he said, I never did anything to this child. I never put my hands on this child in anger. I didn't hurt this child. I didn't do anything to this child. I'm not going to take a plea deal for something I didn't do. But yet his counsel stands up and says, more commonly known as shaken baby syndrome. On page 35 of the closing argument, defense counsel says, yes, I came here in opening and presented to you that there is responsibility in this case. Yes, this is a shaken baby case, but no, this is not a murder case. His counsel is stipulating this is shaken baby, and the science has marched on and now rebutted that shaken baby syndrome is a valid medical syndrome. Has said you cannot rely on that. That is junk science. We've now evolved to a level that says we know that shaken baby, as defined then, does not create that triad of symptoms, and that triad of symptoms can be created by a number of other things, such as over-medication, pneumonia. You could just go down the checklist here of what happened in this case. It has been reported that there was an expert psychologist that supposedly recommended to Robert, just take a plea deal, go to prison, and you can kill yourself once you're there. Now, I can't verify that. I can just tell you it's in the record and has been reported. But yet he refused those plea deals and went to trial, where the jury was wrongly told that abuse could explain, that only abuse could explain the death, and they heard nothing about this child's acute or chronic illness. Now, there's another factor that comes into play here. The jury was told that Mr. Roberson was guilty because he didn't respond in an expected way at the hospital when he brought the child in. flat affect. They were not informed that he was autistic. And that did not come to light until 2018, many years later, when he had an active counsel that actually got him examined and formally diagnosed. We see all through this man's life, which was not a spotless life, let me tell you. He got involved with drugs at one point. He burgled a house at one point, violated his probation, but never is there any evidence of him being violent with other people, assaulting other people, having impulse control disorder, rage, anything of that nature. There is testimony that he was bullied because he was different and lacked social skills that are typically associated with autism, or frequently associated with autism, but he never retaliated. I sat across from Mr. Roberson at the Polunsky unit, and I've spent a lot of my professional career studying and practicing deception detection and interrogation. I've worked with law enforcement locally, federally, in developing these skills and techniques. So I didn't just go have a therapy session with him. I didn't just go talk to him. I was very mindful of deceptive behaviors, and I'm the first to say there are no lie behaviors. People talk about that like there are lie behaviors. There are not. But there are behaviors that correlate with lying. There are behaviors that show up when someone is goes into a stress mode that is associated with not telling the truth and creating something that is misdirection, trying to take you away from something they don't want you to know about them. I ask him hard questions. I ask him point blank, straight up, looking him square in the eye, did you harm this child? Did you shake this baby? Did you put your hands on this child in anger? Did you neglect this child? Did you fail to get this child to a hospital in a timely fashion? He said he had been criticized for putting the child in the car and racing to the hospital instead of calling 911 and waiting for the ambulance. He said he made the judgment call, he could get her there faster. But he was forthcoming and straightforward. It took years for specialists to put the pieces together, the pieces that the medical examiner never did. And I think sometimes, with my years in the litigation arena, that sometimes we forget that the goal of prosecution is to seek justice, not conviction. I think sometimes in the heat of battle and with so much time invested in cases, that it's easy to forget that the goal is to seek justice. And if you get in the middle of a case and you determine, wait a minute, I've got the wrong person here, or I can now see that no crime was committed, that this was a case explained by medicine, this was a case explained by disease, I need to walk away from this one. And when you have a medical examiner that has admitted they never looked at the child's medical records, including the final week where there were multiple doctor visits, And even the child's last 2 days, when extraordinary efforts were made to save the child's life, which meant there were efforts made to stop the swelling and relieve the pressure in the brain, yes, there were things done to the child's head. But if you look at the pathology reports, they contradict what was concluded at the time, that there were multiple blunt force trauma to the baby's head. You look at the pathology reports, they say that's not true. There was one minor trauma to the head that would come if the baby fell out of bed. All of those things were available. And these things not being considered, that's on the state that's seeking to execute this man. And that's why I say there was not due process in this case. There were people that, in my opinion, did not do their job. No one, including me, can say with 100% certainty what happened in that house that morning. My professional opinion is that this is not a man with malice. This is not someone that hurt this child. What I can tell you that goes beyond opinion, after examining the record in this case, the trial transcript in this case, the medical records in this case, this man has not had due process. This man has not had a fair trial. And if we start executing people in Texas absent due process, absent fair trial, we are going down a really dangerous road. That is not something that I can support. And I know that has not happened. As I say, it's a very high standard to take someone's life. We must have the courage to make choices that matter at times that count, and it is always the right time to do the right thing. I welcome this committee's questions.
Doctor, thank you very much, and I appreciate your testimony. I do have a couple of follow-up questions, and then if there are other members that have questions, I'll defer to them as well. I want to focus on Robert's autism. Can you help explain the disconnect that there is between interior life and external expression? How does that present itself with someone with autism, and how does that affect a person that's in the criminal justice system?
Well, how much time do we have? Autism is not a one-dimensional disorder, and that's why it's referred to as spectrum.
Correct.
Because there is a broad range of how autism expresses itself, and it can change across time. What we do know is that there is a difference between internal experience and external expression and interaction. And you certainly see that with Robert. I think that Robert is very flat of affect. I think he is not cognitively agile in expressing himself, and he is emotionally not well developed in terms of expressing, showing emotions, or interacting with someone on an emotional plane the way you would experience 9 out of 10 people that might not be on the spectrum. So you're not going to get a typical response from him in a crisis situation or a normal situation. And having spent 21 years on death row, which is very confining and absent a lot of the stimulation that people normally get, that's going to worsen and deepen the situation in most cases. And as I say, every situation is different. I can speak to Robert's situation in that his world has constricted, as you would think, anyone that's confined in that kind of a space. But to his credit, he has distinguished himself. And he is one of very few that has elevated himself to have some freedom to move about the pod. He has a pretty much spotless record on death row, disciplinary-wise, problem-wise. And he, as someone that is very convicted in his faith and is a strong believer, and he does have people that come and see him and visit with him. In fact, the investigator that led the prosecution efforts at the time comes and sees him on a regular basis, and he's gotten comfortable with him. And that investigator has completely changed his position, believes he made a mistake in pursuing Robert at the time, has asked his forgiveness, which Robert has graciously extended to him. And the two of them have a pretty comfortable relationship where Robert can speak to him openly. And he was much more comfortable by the time I got through talking to him than he was at the beginning. But still, he had very pushed verbalizations. He had a difficult time with eye contact. He had a difficult time relating and responding in what I would call a predictable way that you would expect with someone that was functioning absent the autistic diagnosis.
How long did you sit with him on that occasion?
They give you exactly 60 minutes, and I made sure I got every second from start to finish on a stopwatch.
How far apart were you? What was the physical
There's glass
setup?
between us. He's on the phone and I'm on the phone, but we're maybe 3 feet between us.
Okay. You've conducted interviews over video conference?
I have, and I've conducted a number of interviews on death row with the glass between myself and the interviewee many times before.
Is that something that would have been effective in your meeting with Robert, given his condition?
You know, it's kind of they bring him into a small room. It's probably 3 feet wide, maybe 5 feet deep, and he sits at a desk much like I'm sitting here. And the glass is kind of at the front edge of this table, and he kind of leans in on the phone. And it's kind of a comfort zone for him. I mean, he doesn't like a whole lot of stimulation, but you know, he leans in and participates. And I ask him a variety of questions about history and what he could remember and not remember. And you know, some things he didn't have clear memory of, and he owned that. I asked him questions to test his abstract thinking. He did not do well on those things. I challenged him when they said they wanted to go see his home where he found her and brought her in. And he said, "Sure, I'll take you right over there." I said, "Does it strike you odd?" And there's of course a video record of this, so you can see exactly how that exchange went. But I said, "Did you feel bad? Your daughter's fighting for her life there, and they say, I want you to get in the car and take me home. Did it occur to you that I don't want to leave? I'm going to stay here with my daughter?" And he was like, "Well, that's what they told me I needed to do, so I took him home. I mean, that's what they told me to do." He was very compliant at the time. I said, "Did you want to leave?" And he said, "Well, that's what they told me to do." That's what I mean. He's a very compliant individual, and he didn't have the ability to express the emotion, "I'm not going to leave my daughter." He just complied and did what he was told.
So and that's what I was trying to drive at. And you mentioned that he had a comfort zone. So if someone like Robert's out of his comfort zone, he's got limited affect and emotional range, limited mental agility, like you said. All of those things I would think would be exacerbated if he's appearing on a screen and seeing others on a screen, as you and I learned how to do during the pandemic.
Well, yes, I think he needs every cue that he can have to grab onto and relate. You put him two-dimensional, and he doesn't, he needs cues. He needs physical feedback, and it makes it difficult if he can't have that. And his ability, we have to do everything we can to help him assist in his defense. And we can see from the trial record, 22 years ago, he didn't have a very good facility to assist in his defense at the time. If he had, even when he was there every day with his lawyer sitting next to him, if he had the ability to say, "Wait a minute, I've told you I've turned down plea deals, I don't want to do this, why are you standing up saying this is shaken baby case?" If he had insisted that, look, this medical examiner's not talking about the evidence here. I mean, the cause of death was the child had a bacterial infection, was septicemic, and had a necrotizing infection that was eating lung tissue. If anybody here had been in that situation, we'd be saying, "Hey, we need to be talking about this. You don't need to be telling them something I've told you I didn't do. We need to be talking about an alternative explanation about why we're here." And he had a difficult time doing that when he was present at trial. If he had been on a screen, the ability to initiate contact when he's not in the room would be nil.
Okay. I have one more question for you, then I want to pass it off to my colleagues that have questions. If someone was sitting in that other chair next to you and their testimony was to this committee that this was not a shaken baby case, how would you reply to that?
Say that again.
If someone was sitting there next to you and their testimony to us was this was not a shaken baby case, how would you respond to that?
Well, I agree. It was not a shaken baby case.
I'm sorry, I apologize, that it was a shaken baby case.
Yeah, I was trying to figure out where
Yeah,
you're going with
I
this.
apologize. That if they,
Well,
If-
first thing I would say is there's no such thing as shaken baby syndrome. Now, listen, if I'm not asking people to believe that a full-grown adult cannot pick up a 20-pound child and do serious or fatal harm to that child. Of course they can. Of course they can. They can pick that child up and bash its head into a wall or throw it on the ground or whatever. but there are going to be very clear signs of that having happened that were not present in this case. What is known as shaken baby syndrome depends on this triad of symptoms: subdural hematoma and brain swelling and retinal hemorrhaging that you see in the eyes. That triad of symptoms has been debunked. That's not what happens if a baby is shaken, and that there are a myriad of other causes, such as over-medication or absence of oxygen to the brain, or septicemia, other things that can cause those symptoms. If there are alternative explanations, then that's no longer a valid syndrome. And there have been a number of exonerations because of this. That was the science at the time. Science evolves, just like DNA technology evolved, and so there have been exonerations with DNA. The same thing here. There have been a number of shaken baby convictions that have been exonerated because they have come back with new science that says there's an alternative explanation for this. You can't convict someone on something that has now been debunked by the medical community. Even the individual who initially identified shaken baby syndrome said that was not the intent. I did not intend for that to be used as a prosecution for injury to a baby, and it has been debunked and disproven by the medical profession and is not used. So fortunately, science has progressed, medical science has progressed, and there's now new evidence available that should be used.
Well, I appreciate it. I do want to apologize for misspeaking. I was up at 3 a.m. to make a flight here today. So apologies for that.
I know
But-
you've been very busy.
But thank you I appreciate your testimony. I may have some questions following up a little bit later. But what I'm hearing from you very clearly is you've read the transcripts, you've reviewed the record, and there is not any way that someone could maintain that the state came here and said that they didn't try a shaken baby case. That's what they told us last week. No, we didn't try a shaken baby case. Sounds like you've reviewed the record, and it sounds like your opinion is those facts speak loudly that is what they tried to do in that case.
Well, as I said, I stopped counting it 47 times in the record, and I read you quotes from the defense, certainly what the defense attorney tried. That was in voir dire, opening statement and closing argument, quotes from the defense attorney stipulating this was a shaken baby case, despite Robert's assertions that was not the case, and he rejected plea offers and said, I'm not going to take a plea on something I didn't do, but yet then they got up and said, well, he did do it. His own lawyer said he did do it.
Thank you. Vice Chair Cook?
Thank you, Mr. Chairman. So, Dr. Phil, before you became Dr. Phil, can you tell us a little bit more about CSI? I think you've been a little modest so far when you said you've been involved in litigation. I want you to be a little more specific about your background.
As I say, I had kind of three areas of focus: clinical, the medical psychology, and my focus in medical psychology was brain and central nervous system. And then I did a year's postdoctoral fellowship in forensic psychology, or psychology in the law. And I was a founder of a company called Courtroom Sciences, Inc. It was the original CSI. Probably should have enforced that.
I think so.
But we had a full-service trial science firm, and we were retained by clients to evaluate cases and We did strategy for cases. We assisted in jury selection, witness preparation. We often had mirror juries, shadow juries in the courtroom that matched the jury that was in the jury box, and we were able to debrief our jury. So what I'm saying is, if we had 12 jurors in the box and there's 7 women and 5 men, then we had 7 women and 5 men in the gallery that matched them. So if we had a 42-year-old woman with 2 children, a barking dog that was a Baptist with a year of college, then we had a woman out here that was 42 years old with 2 children, barking dog, a year of college that was a Baptist. Because you can't talk to the jury every night, but you can talk to your shadow jury every night, and it gives you insight to that. We mock tried cases many times before they went to actual trial to find out, how a jury in a particular venue was likely to view a case, and what was important to them and what was not important to them. The difference was at mock trial, instead of having 1 jury, we seated 4 or 5 or 6, and they went to independent deliberation rooms, deliberated over the actual jury charge as best we could predict what it was going to be, and all of that was videotaped and then analyzed very carefully to see what their problem-solving strategy was going to be, what was important, what was not important, so we knew what to emphasize and not emphasize. Whether this particular expert was effective or the other expert was more effective, what they wanted to hear and not wanted to hear. And we focused on telling the truth effectively and getting the best result we could. And sometimes the answer was, you need to settle.
Sure.
Thank you. And we did criminal cases and civil cases, both.
Well,
Defense and plaintiff.
as a former client from a couple of decades ago, I've seen you in action, and I can attest to your skill set. And just want to say thank you for being involved in this case. Thank you for being willing to be here today and take time out of your busy day now that you're Dr. Phil in a different role than what I knew you as a couple of decades ago. But I think I just wanted everyone to know that background. It's not like it's not the typical person talking to a few jurors. You've done this for decades, correct?
I have.
And you said you read the record. Did you see discussions about a sexual assault of a child involved in the record?
I saw discussions of the sexual assault early on. It was brought up concerning 3 anal tears in a child, I believe it was. This was early on, and it seemed to me that it was brought up to prejudice the jury, frankly. But then it was dropped out later and was not part of the jury charge. It was not something they were asked to render a finding on. And it was not something that they prosecuted on at all. I felt like it was there because it's, if you want to inflame a jury panel, then you can put that into the mix. But then it was completely dropped out. It was not paid off. There was no evidence offered about it. No testimony was given about it. There was nothing in the medicals that were offered about it. It was just put in early, but then it was never paid off later.
Fair to say, if we were to grab 100 people off the street, that probably all 100 of those people would agree that that would prejudice the jury, that they heard that type of testimony prior to going to deliberation.
Well, it certainly would, and but as I say, in opening statement, you're not allowed to argue. You're just you're just going to say, we believe the evidence will show, and then the jury is expected to say, well, they made that promise. Let's see whether they bring it or they don't. And then in closing argument, the opposing attorney would be expected to say, they stood up and brought this up. Did they ever show you anything to do that? And with something that inflammatory, there's a real question about whether you even want to bring up that they didn't pay it off, because you're reminding them, and it puts it back into the juror's mind. So do you bring it up again, or do you just leave it there? It's a difficult call. But if you examine the record, you will see that there was never one word of testimony from an expert or otherwise to show that there was any even insinuation. And Dr. Francis Green filled out an affidavit on July 9th of this year, and she basically said in her affidavit that if she was going to render an opinion on what the cause of death was and what she saw, there was certainly no mention of that. She disagreed with the cause of death, and she had a firm opinion that the death was caused by severe undiagnosed viral pneumonia, onset of which occurred at least a week to several weeks before her collapse, that there was a viral interstitial pneumonia complicated by secondary necrotizing bacterial bronchopneumonia several days to a week before the death. Necrotizing meaning that it was actually eating tissue in the lungs. And so as a result of bacterial infection, she became septicemic, resulting in all of this coagulation reflected in lab results, and that it was a combination of drugs suppressing respiration, and this was the phenergan or promethazine in two forms, suppository and cough syrup, and none of this other was mentioned at all anywhere in that.
And I know you're not a medical doctor, and I don't expect that you've memorized everything about this case, but do you recall the cause of death as testified to by the medical examiner?
She reviewed so little about it. She just referenced the triad of symptoms and shaken baby, and I can pull up what she said here.
My understanding, and I've not reviewed the record to the level that you have, but my understanding is that there's a certain designation when it is a shaken baby syndrome case, and it's not. It doesn't say shaken baby syndrome on the cause of death, and so I didn't know if you had that available.
No, I can probably find it for you, and I'll get it for you before I leave.
Okay. And if not, we can come back to it. What about as far as the defense attorney a while ago? You said that you would debate whether or not it was proper to bring the sexual assault back up, and would it also be proper to ask for a mistrial? I mean, based upon inflammatory assertions.
Absolutely, I would think that absent any evidence, any witness, no evidence whatsoever, I would think you could move for a mistrial, but that's certainly not in the record.
Okay. And then as far as if in your opinion, is the relief that, the best relief that could be granted would be by the Court of Criminal Appeals in the form of a new trial? Do you believe that that's the best case scenario?
Well, I certainly think at a minimum, there should be either an evidentiary hearing to show how this man's rights have been violated, and or a new trial, which I think would be pretty clear.
And would the two best pieces of evidence that you know of, would it be the CAT scan of the brain and also the photo that you showed earlier with regard to the child's lungs?
I think that, along with the history of her going into respiratory distress absent him being in her orbit. I mean, he wasn't in her life when this started happening. And listen, if I need to say, I work with the Innocence Project some, and for a number of years, and I've had cases brought to me that I look at, and I've been to death row and interviewed inmates and walked away and said, I'm not
feeling it.
not feeling it at all. I can't, in good conscience, say that I can get behind this. If I can't study the record and look the individual in the eye and passionately believe that there's been a miscarriage of justice, I just don't step up to them. So I don't get involved with everyone that's presented to me by a long shot.
Sure.
But when I see something like this, you can't walk away.
Well, thank you for being here today, and thank you for your testimony.
Chairman Leach.
Thank you, Chairman. Doctor, thank you for being here today. Just a few quick questions that I really want to focus and drive home with you, and I want us to try to take a step back together, because I don't know if you were able to hear some of our opening remarks, but I thought Representative Darby put it very well in his opening, in that we are not here. It is not our role as the legislature to retry this case. We have to be very cognizant and careful not to act as some sort of super appellate court. And I hear those concerns, I share those concerns, and we have to be, members, laser focused on staying in our lane. Does that make sense to you, Doctor? Of course.
Certainly.
Okay. So I want to be, this has been a very, very helpful, a very thorough and helpful overview, not only for the members of this committee, other legislators tuned in, the people here, but for all of those tuned in or watching online who are focused on this case. And I think the question that, as I seek to wrap my arms around this and think about the very purpose we're here, and I think about representing my constituents, Doctor, is I want to ask you this question. I think this is maybe what people who are tuned in right now are wondering the most. How does this happen? If everything you've said is accurate, and I believe that it is, in my own independent review of the record, everything you've said is 100% accurate, and there's a lot more that you haven't gotten to. How does this happen in our system? And if we're here to recognize holes in the system, weaknesses in the system, problems in the system, to strengthen our criminal justice system, Doctor, I would ask you to answer that question. How does this happen? Because to me, this is not a shaken baby case. This is an ineffective assistance of counsel case. And my hypothesis is that had Mr. Roberson had effective assistance of counsel, as he's constitutionally able to have, then we wouldn't be here today. Do you agree with that? And can you kind of can you go into more in depth on why this has happened and what we can do to fix it?
Well, you know, I talked about what we did at CSI, for example, and some people might say that in America you're entitled to the best defense money can buy, and we did a lot of pro bono work. You know, we either charge our fee or we charge nothing. Because if you look at the population on death row, or you look at the population in prison, there's an overrepresentation of minorities. There's an overrepresentation of low socioeconomic.
Rich white guys don't get the death penalty, do they?
No, they don't. And they don't get a lot of prison time, either one. And so the fact of the matter is, when you get a public defender, and I know a lot of public defenders that are passionate, dedicated, and hardworking. And they got a stack of files on the corner of their
That's right.
desks that you can't even see over.
That's right.
And then I know some that are just, kind of checking the boxes. This is like everything else. There's a broad range, but I know a lot of dedicated, hardworking public defenders. But they're just so overworked and spread so thin that it's just impossible to give a fair representation to every client. But if you look at the number of exonerations, it's scary. You're either for the death penalty or not. And if you are for the death penalty, you have to be for doing everything in your power to ensure that those who face that ultimate sentence have had a fair trial and are guilty insofar as we can determine. I mean, you have to do everything. You can't kind of say sort of maybe we've got this right. And if 1107 says you can't do junk science, you can't have something that has evolved, and we're going to ignore that it's evolved and just use what was there at the time and keep them in jail, even though we now know better.
Sure.
If you execute people when you now know better, you need to abolish the death penalty. If that's the standard by which you're going to execute people, then you got a bad system.
So am I correct in assuming that Mr. Roberson could probably not afford CSI, correct?
Yeah, probably.
Okay, he couldn't. I mean, there's other. It's not casting aspersions on CSI.
No,
I've worked with
listen,
CSI before, and they're the best in the business. But the point is that Mr. Roberson simply could not afford the resources to provide himself not only effective assistance of counsel, but the full assistance of counsel for a capital murder case in which the prosecutor decided, I believe, grossly negligently so, to seek the death penalty on. Mr. Roberson was afforded the minimal, and that's probably even being generous and putting it nicely, the minimal assistance of counsel. And in many cases, his counsel actually worked against his interests. And so my opinion is that he had virtually no counsel. And I, like you, and I think many members of this committee and other legislators, we get asked, Doctor, you might know this, but we get asked all the time. We get letters from inmates on death row. We get asked very frequently to review cases, to get involved, to speak out. Since I've been in office 12 years, I've received maybe over 100 of them. And I've only gotten involved in 3 death penalty cases. The case of Jeff Wood, the case of Melissa Lucio, and the case now of Robert Roberson. And without fail, in all 3 cases, it all comes back to ineffective assistance of counsel, because all of the facts that you've talked about here, all of these questions, all of the evidence that was not introduced at trial, the jury had no knowledge of it, members. None of that none of that is part of the appellate record. And so the system cannot work when it's built upon a foundational basis that all this evidence is not part of. So our courts of appeals can't review the evidence. The record is so defective. The case in and of itself is so defective. And so let me ask you this in closing. Do you believe that if Mr. Roberson is simply afforded a new trial, which is all I'm asking for, I believe that's all I don't want to speak for the members of the committee, but that's what I want, is just a new trial where maybe we could get him effective assistance of counsel and have someone like CSI prepare his defense and present all this evidence. Do you believe there's any way that he would be convicted of capital murder?
I do not. I do not think he would be convicted. I think this is a case where there was no crime committed. I don't think we have the wrong person. I don't think a crime was committed. I think this was a case where, tragically, a child was chronically and acutely ill. I think there was some problems with medication, and I think that contributed. But I certainly don't think that this child was aggressed against. But what I've said is, when you have a circumstantial case, we don't know what happened behind those closed doors. I can't say that with 100% accuracy. I would be going beyond my skill set to say what happened behind that closed door. I don't know that. He woke up at 5 a.m. and says he found this child on the floor and with labored breathing, because she'd been sick for quite a while. He says he was able to get her feeling okay and put her back to bed. Should he have taken her at 5? I wasn't there, didn't see her, don't know. But he testifies that she got to feeling better, and this wasn't a new thing. He had only had her for a couple of months, but you saw the record, 46 times across 2 years. Put her back to bed. Then he finds her again, and now he races her to the hospital. I don't know that any crime took place, and I think if this full record and the testimony from Dr. Green and other pathologists, I think they would say no crime was committed here at all.
Doctor, thanks for being here.
Chairman Darby?
Excuse me. Dr. Field, thank you for coming today. Your testimony is invaluable to us. First of all, the name Shaken Baby Syndrome. To me, that connotes guilt on the face of the charge. If you've been charged with Shaken Baby Syndrome, it would indicate to me, at least, that somebody shook that baby to death. And since you were the last person to be near that child, that you were therefore guilty by simply being charged with the name. What are your thoughts on that? Whether psychologically to a jury, just being charged with Shaken Baby Syndrome would indicate in the jury's mind that there was a crime committed, that you've now said perhaps was no crime. What are your thoughts on that?
Well, I think you're exactly right, Representative Darby. In psychology, we refer to something called iatrogenic label, where the label itself creates more problems than what it describes, and that is a very toxic label, obviously, and that's why I say I think sometimes burden of proof is a myth. When a jury hears something like that, they go, wow, if that's not what we're down here for, we have a dead child, and they're pointing fingers over here at this guy who doesn't seem to be terribly sensitive or upset. And if we're not down here for that, somebody needs to give me a really good alternative explanation, because they're looking over here. It's just like this setup right here. You got that big state seal up there and those flags beside it, and you got armed guards over here and all, and there's an awful lot of entrapments to this situation, trappings to this situation that make it seem awfully official. And then you got this guy over here, and the prosecutor knows the judge, and the judge knows the prosecutor, and they're calling each other by name, and the court clerk, and all is like, "Hi Betty, how are you today?" And it's like everything seems against the guy that's there for the first time ever, and so there's a lot of momentum here. Somebody better have a really good alternative explanation, and there was a really good alternative explanation The only flaw was it never got mentioned. It never got told, which is why I made the point that jurors make decisions on what they see and hear, not on what they don't see and hear. All of this that I talked about today never got into the court record. It never got reported. Nobody ever put all those pieces together until 18 years later, when the Innocence Project with pro bono lawyers and all come along and start piecing it together, and then they come to me, and I have my whole team at Merit TV, and everybody starts coming together, and now all of a sudden you have a valid defense team, and now you get an alternative explanation.
Well, I made a statement before you came into the chamber here, but the purpose of this body and committee, in my opinion, today is to examine our current law that's on record that we created. There was a problem when convicted people could not get their matter heard on appeal because there was not an avenue created by the legislature. We created it. And so in 2013, we addressed that deficiency. I'm going to be kind of a long question, but if you'll bear with me. We said that specific facts must be available that indicate relevant scientific evidence was currently available and was not available at the time of the conviction because the evidence was not discernible through reasonable diligence at the time of the trial, and the scientific evidence would be admissible under the Texas Rules of Evidence at a trial held on the date of the application. And finally, the court would have to find that if the scientific evidence had been presented at trial on a preponderance of the evidence, the person would not have been convicted. Okay. Now, that did not go far enough. So 2 years later, in 2015, we passed another law and said the courts would now consider whether the field of scientific knowledge, not junk science as we conveniently refer to it, we now refer to it as the field of scientific knowledge had changed. The court would also have to consider a new item, whether a testifying expert's scientific knowledge had changed. And so we created those standards. And what I'm trying to get to, did we go far enough or did we go too far? For example, it bothers me that the Court of Appeals seems to be taking a higher standard. They say that the evidence must reflect that the accused would be innocent. I don't think that's the standard by which we anticipated or created in 2013 and 2015. This almost, and several of the witnesses, I think they're going to testify again today, it's almost as though this habeas trial, it's kind of like a game of football. You're going to win or lose. I mean, instead of trying to determine, in your words, the goal is to seek justice, it doesn't appear that the functionality that we've created in the Court of Appeals is designed to seek justice, or is it simply designed to see who wins and loses? That's what's bothersome to me. Have we created language that would suggest the Court of Appeals is saying, no, that evidence has to show the accused is innocent, when I don't think when we voted for this bill in 2015, 2013, that was a level of examination that I don't think we created. So I guess ultimately I'll come to a question. The question is, do you think that our current law for scientific knowledge has changed, and whether or not we had an expert testify, not changed his testimony, saying that he believes he wasn't innocent. I mean, he wasn't guilty. Do you think our current, and I've given you the factors that compose what we're trying to address here, is that science has changed. Do you believe that we followed that law, or the Court of Appeals has followed that law? And if not, what should we include in statute that will assure that following?
Well, I can answer that. Can I answer that in two parts?
Sure.
One is, I think it needs, whatever it is, needs to be followed evenly. I believe it's the Roark case that last week or the week before, a new trial was granted, correct? But in this one, it's not. So, I mean, it seems to me like it needs to be evenly applied. So I'm wondering, how do you explain that to Mr. Roberson's family? And then secondly, I think there's some simple language that might help. And now, I'm not a lawyer. I don't mean to brag, but I'm not. If you added something to it that said, in the event the filing is on behalf of a convicted person to be executed, the court shall stay the execution and grant the convicted person a new trial if the relevant scientific evidence was not available to the convicted person in light of his or her circumstances, and/or that relevant scientific evidence contradicts scientific evidence relied upon by the state at trial. So if it's evolved and it wasn't available at the time, they ought to get the best science available that bears on their conviction. It seems to me when they're executed for a long time. And you see something as clear as the case I cited earlier about Mr. Byrd. It took from 97 to 2019 to execute one of those perpetrators. In a circumstantial case, how can you not justify saying science has evolved? They get the current science, which is what this says, and I'm happy to share this if anybody wants it.
Okay.
It just says they get the current science.
Well, thank you for your testimony.
Representative Bowers. Oh, I will follow up with you, Doctor, and take you up on that offer to submit that to the committee.
I will.
Representative Bowers.
Thank you, Mr. Chairman, and thank you, Dr. Phil, for being here today. I am certainly a fan, and, I know that your show was a spinoff from Oprah, so I'm certainly a fan, been a fan for a long time, and I will say to you that I am glad to have this privilege to ask you some questions because we know you ask the hard questions. You mentioned that a little bit ago, and before I get to my question, my pastor, Richie Butler, said to tell you hello and that let you know he's my pastor. But I'm so glad I get to ask you the questions and I didn't get called to your show for you to ask me the questions.
Fair enough.
But I want you, if you can, to take us back, and I promise you I will watch it. I have not watched the interview with Robert Roberson, but can you take us back to that time when you did have a chance to talk to him, since we won't get to hear from him today in this chamber? And I just want to know, because you mentioned, and we heard this before, that he was very flat in his responses, and we do know that he's on the spectrum. So I just wanted to know if you can share a little bit more about that time and moment and what those answers, because you said you asked him some pretty hard questions, and what his responses were like, and what, was there remorse there? How did those responses come out? I would just like to hear a little bit more about that.
Yes, I will. When I sat down with him, the Pulaski unit is one of the best run units in the United States, I have to say. And I've been to many prisons and talked to many convicted murderers, and that unit is, I have to say, it's really well done. They treat their prisoners with dignity and respect, and they do things the right way there. And when I'm permitted to come in, I respect their rules as well, because everything runs. Order is really important to keep everything running the way it should. And when they tell you that you're going to have an hour, I really try to respect that. And so I sat down with him in the beginning and said, listen, we're on a time clock, so I'm going to forego a lot of small talk and jump right into this if it's okay with you. And he said, certainly. So we jumped right into it, and I said, you're days away from being executed, and I want to know how you feel about this. And I started asking him about things, and I asked him some things like, are you bitter? How do you feel about this? Are you angry? Are you bitter? How do you feel? And and I'm spending as much time hearing what isn't said as what is said, how he's answering, what his eye contact is. And he's very very flat and very robotic, and he says he's not bitter at this point. It's been 21 years, and I guess you can stay angry for just so long. And he says he's really not, and he spends a lot of time in his Bible and reading the Word. And I asked him, I said, you've been in trouble before. Tell me about those sort of things. I wanted to see if he tried to deflect or minimize those things. He was very forthcoming about it. He said that he had gotten into drugs at one time, and that caused him to make a lot of bad choices, and he got in trouble for it and seemed to feel like he should have, that he did things he shouldn't do, violated his probation, got time added to that for it. And again, he didn't try to minimize or whatever. He was straight up about that. I asked him about his relationship with Nikki, and he said that he had only been around her for a couple of months, and that she was pretty standoffish with him and seemed to kind of be afraid of him, but that they had started to break that down some, and that there was some warmth, and she started to sit in his lap and let him hold her and that sort of thing. I asked him what he did when he was angry, for example. He said he went off by himself and spent time alone. I asked him if he ever put his fist through a wall or slammed doors or broke things or pushed people or yelled and screamed and whatever. And he said, I just kind of go off by myself. I don't, whatever. I gave him some cognitive challenges. I asked him some simple things. Like I asked him, interpret this saying for me, shallow brooks are noisy. He had no idea. I said, still waters run deep. How about that? No idea. I said, if I gave you a screwdriver, a flat screwdriver, you could screw a screw in and screw a screw out with it. What else could you do with it? Couldn't think of one other thing you could do with a screwdriver. Nothing. I gave him some items to remember and asked him to recall those, not after an hour, but after about 15 minutes. I think he got 1 out of 5. And so he was having trouble. Of course, he's under a lot of stress, too, and that doesn't help. And then as I asked him straight up, did you hurt this child? And I really watched him, and
Yes.
his blink rate's about 12, 13 per minute. You go under stress, if you ask a relevant question, people are lying that blink rate will often go to 70 or 80 in a hurry. He didn't change at all. He didn't color up. He didn't stutter or start, changing his patterns at all. Just no, no, and no. And I asked him if he thought he had had a fair trial, and he said no. His lawyer kept saying, shaking baby, and I told him, why are you doing that? That's not true. I don't want you saying that. But he said, I'm trying to save you from first-degree murder. That's what they're charging you with. But he said, well, I don't want you saying that. And he said, well, just sit down. And he was very hopeful that he was going to get some kind of relief here and not be executed. And he thinks he deserves to be free.
Thank you for that. And thank you for giving us a snapshot of what that interview was like. And I certainly will be going back to look at it and view it. But and thank you for asking him questions, like you said, the hard questions, but then certainly some simple questions. So, and sharing that with us, I really appreciate it. And I have to say, I'm so glad to be on asking you the questions.
Thank you.
Thank you, sir.
Yes,
Thank
ma'am.
you.
Representative Schatzline.
Thank you, Chairman. Dr. Phil, thank you for being here.
You bet.
I said this is the last hearing, and I'm going to keep saying it as loud as I possibly can, and that is that justice that requires unsubstantiated assumption is not justice at all. And I think that's what's so valid about you being here and you doing that interview. Thank you for using your platform to get truth out. And so I had a few shotgun questions for you, just to get a 5,000-foot view of anyone who is watching. You said that juries decide this on what they see and hear, not what they don't see and hear. Did the jury know that Nikki had been chronically ill her entire life?
No.
Did the jury know that she had 2 recent episodes of a sudden halt to her breathing, or we would call it breathing apnea?
No.
Did the jury know that she was brought into the hospital with 104-degree fever?
I don't believe that was in the record.
Did the jury know that one of the drugs that was given to Nikki is no longer used on children and has a black label because it makes it difficult to breathe for children?
No.
Did the jury know that she had been diagnosed with bacterial pneumonia?
No.
And you mentioned that Robert was not perfect and in some ways had a troubled past. And I think it's important to point out, because we're talking about an execution, a state-sanctioned execution. To your knowledge, has Robert ever been convicted of a violent offense before or after this trial?
It's not that we've been able to find. We've seen the burglary and the drugs, but no violent crimes, no assault, no mugging, no assault with a deadly weapon, nothing like that.
Right.
We've not been able to find anything like that.
Right, I would agree with you. So even though a jury that's never gotten to hear any of these details, is it possible that the bacterial pneumonia mixed with a combination of dangerous drugs, some of which are no longer available for children because they're deadly, mixed with a fall off the bed, is it possible that these factors alone could be the cause of death?
Well, according to, again, I'm not a physician, but I can read, and according to the pathologists that have reviewed this now, definitely conclude that that is a viable cause of death for a vulnerable child that had chronic pneumonia and was septicemic.
So with that being said, do you believe that the junk science law has been violated in Robert's case?
Well, I think it clearly has, and I think there are a number of exonerations in very parallel cases to substantiate that. And again, I don't want to get out of my lane. I'm reporting to you what the research says. I am not a physician. So I'm telling you what the physicians that have been brought into this case are reporting and what the medical research that's available to anyone that can read reports, and what other cases that are a list of exonerations that I can share with you. Exonerations have taken place where they've determined that no crime was committed at all because of exactly the things you're listing out.
Yes, I agree with you. In fact, the number that you're talking about is 32 exonerations that we've been able to find of those that were convicted of shaken baby syndrome. And so you said that the death penalty hangs in the balance here, and I agree with you. So is it your opinion that a reconsideration by the Criminal Court of Appeals and giving Robert a retrial actually strengthens the legitimacy of the death penalty in the state of Texas?
Well, I think it does. I think there's been over 5,000 years of time on death row served by innocent people that were ultimately exonerated. So, and Texas is second only to Illinois in the number of exonerations. So we need to get this right. If we're going to preserve the death penalty, we need to show a commitment to do everything possible to get it right. And if we're not good stewards of that, then we shouldn't have the privilege of asserting it. So if we want to preserve it, we need to be really committed to getting it right.
I couldn't agree with you more. As a member who is supportive of the death penalty, I also believe that if we are going to execute people in the state of Texas, we have to be sure at the highest level that we can that that person committed this crime. As someone who wants to fight for individual liberties, this is something that has to be at the forefront of our mind. And I couldn't agree with you more that this actually, a retrial would strengthen the position that the death penalty should be a viable option for the courts in the state of Texas. Thank you for your testimony.
Thank you.
Representative Bojani?
Thank you. Thank you, Chairman, Vice Chairman. Thank you, Dr. Phil, for being here and for letting the committee know numerous issues, including the tunnel vision in trials. That is the focus too narrowly on one explanation, which happened to be here, shaken baby syndrome. What changes would you suggest to prevent this kind of confirmation bias from affecting investigations and trials in the future?
Well, I think there has to be some focus on being sure that we aren't looking over our shoulders and doing what's historically been done. But if we get into a situation, somebody has to be willing to step up and say, where are we now? Things are changing at a really rapid rate. We're learning so much more about how things are happening, and medical science is advancing, as is we've seen it with DNA. We're seeing it with shaken baby syndrome. We're seeing it across a lot of different fields. So we just need to be sure that our prosecutors are really held to a standard of looking at where science is in a given area in circumstantial cases. And I say circumstantial cases because nobody was there that morning, so they have to look at all the circumstantial cases. And I also want to say that the people at the hospital that morning who waved a red flag and said, hey, we need to take a look at this, were not wrong. When somebody shows up with a baby that is in distress like that, and you've got somebody standing there and they don't seem terribly concerned about it and all, look, those are social worker, psychological red flags. And somebody should pay attention to that, because oftentimes they would be exactly right. There's a lot of abuse that happens with children. And somebody, I would rather be wrong 99 times than miss one for sure. So I do not fault those people for asking that question and saying, hey, time out, let's see what's going on here. But asking the question and going down a tunnel vision and snowballing somebody to death row are two different things. Somewhere along there where you ask the question, That's valid. But then not saying, okay, but let's wait a minute here. Let's ask all the questions. What's this child's medical history? We've got a lung scan. They didn't wait for the lung scan before they determined it was shaken baby syndrome. They called for a brain scan and a lung scan and did not wait for the results before they decided what they were going to do. And that's my problem. My problem is not with them saying, hey, red flags here, we need to start asking some questions. Not a problem with that. The problem is they didn't follow up on available science to determine whether or not this was a chronically and acutely ill child. This child was septicemic. This child had chronic pneumonia, and there were scans done that they didn't take into account. Not even the medical examiner took them into account. The medical examiner admitted a list of things that were not looked at. That's the problem. If you're going to see the red flags, and you should, then make sure you check all of the different areas that you can get data from.
Got it. Thank you. One more quick question. I know there are a lot of people here that are listening in that care about, people live with autism. So in future cases, how can we ensure that individuals with autism spectrum disorder receive appropriate accommodations during the trial and post-trial proceedings, that they are treated fairly and their needs are fully considered in the justice system?
Well, this was not diagnosed until 2018, so no one gave Mr. Roberson the opportunity to be evaluated, and I think I did not see him 21 years ago, but I can tell you in spending time with him, and I just spent an hour with him, I cannot diagnose this individual in an hour through a glass and all that. So, but I can tell you this, we're talking about red flags. In the hour I spent talking with him, questions were going off in my mind about his ability to assist in his own defense. And if he was anywhere near that level of functioning 22 years ago, someone should have stepped up and said, this individual needs to be evaluated, and the state needs to do that. And I don't know what that evaluation would have shown. I can't. All I know is that I've seen the report that he is on the spectrum at this point, and all, but I can't diagnose him, but I can tell you big red flags were going off when he couldn't, he was not showing the cognitive agility or the reasoning that I would have thought you would want to assist in your defense, and so I would have thought an advocate would have been really nice to have him at his side during that trial. And the autism community now is so great in assisting those. But I think that he needed to be evaluated at the time.
Okay. Thank you.
Representative Harrison, did you have any questions?
Yeah, just a couple quick ones. You've covered this rather extensively. Thank you so much for that. I just want to go back to a couple things. One, from your previous discussion with Chairman Moody on something that I found concerning, and I'd like you to maybe clarify some of your previous remarks with him, because I have been surprised to see over the last few days the state now start making assertions that that the prosecution was not predicated on a shaken baby syndrome hypothesis, and that in fact this was not that, but that this was effectively a battery case, and that this child had been beaten. How would you characterize those representations that we are now hearing from the state?
Well, I think a careful analysis of the trial record would suggest otherwise. I think all you have to do is look at the trial record and go through and look at their arguments, and they tried to shake a baby case. I mean, if nothing other than the defense voir direing the jury on shake a baby, doing an opening statement on Shake a Baby and doing a closing argument on Shake a Baby. That's certainly what they were defending. If nothing more than his own representation, it was a Shake and Baby case.
And that's absolutely consistent with my examination of the record in this case. And what was one of the early things that struck me, and tell me if I'm wrong here, if I'm oversimplifying this, I want to get it right. You effectively had a case where the state, the prosecution, was arguing shaken baby syndrome. And the defense attorney, his counsel, said, and I believe it's a direct quote, "Yep, classic shaken baby case." And given that 20 years ago you could presume abuse, what was left for the jury exactly to decide?
Yeah, it was just, I think the argument from the defense was it didn't rise to the level of first-degree murder that he snapped, or it wasn't premeditated or whatever, just he lost it in the moment.
So was there any arguments or evidence that the jury heard that this was not a shaken baby case?
I think there were other things that went along with it, that there were bruises on the left side of the face, to the jaw, and to the chin, and multiple trauma to the head. But I think that you have to break it down and say, well, when was the trauma to the head? Because from admission to the hospital to the time the pathologist got involved, there were other insults to the head in life-saving efforts where you try to do things to relieve pressure off the brain, but those weren't there when the baby came in. They were done when they started doing things to try to relieve the pressure.
Right. So how much time to those things that you said that were related things that kind of were brought up? How much time at the trial was spent explaining to the jury any alternative explanations for either the shaken baby triad or for the other things that were observed on the baby?
None that I could find.
Yeah, none. So was there, is it fair to say that there was, or I'll ask it, was there direct evidence of abuse at trial at all, or was it all circumstantial?
It was all circumstantial. Well, it was all circumstantial or reported by witnesses who later impeached themselves by saying, I was coerced into saying this with threats from Child Protective Services or implied threats from Child Protective Services or whatever, that changed their testimony.
I hear a lot of people out there right now saying, we should just trust the jury. They convicted him. In your opinion, is it even a debatable question whether or not the jury had all the evidence necessary to make such a decision?
Well, I have to answer that two ways, Representative Harrison. I think jurors tend to get it right. Day in and day out, I think jurors tend to get it right based on what they see and hear.
Correct.
Based on what they see and hear, I think the collective IQ of a jury is 1,200. I think you send them back into a room. I think most people take it seriously. I think they put their heart into it, and I think they get it right based on what they see and hear. And I think they probably got it right in this case based on what they saw and heard. But they didn't see and hear everything they needed to see and hear to render a just verdict.
Do you think that's even a debatable question?
Not even close.
Yeah. If I can dig in real quick on something you just said, you mentioned that witnesses that may have impeached themselves. Can you give is there a particular example or a particular witness that you're thinking of?
Well, yeah.
If there's not, it's okay.
No, it's okay. There are witnesses that testified at trial, and they were witnesses from his past, and
the reason I actually asked, because Representative Schatzline a minute ago had made a question about, whether there were substantiated or unsubstantiated discussion of violent behavior in the past that came out at trial.
Yeah. Okay, on page 12 of the main document. Okay, got it. Let me turn to it here. Teddy Cox, who was Robert's girlfriend at the time, she was going to be the subject of a CPS investigation, so she was urged to provide information to implicate Robert, and was confined to a psych ward and admitted on the stand that she changed what she said about Robert based on how she felt at the time. But rebuttal witness Patricia Conklin, Teddy's sister, said Robert had a loving relationship with Nikki, never saw Robert spank Nikki, and Teddy had a poor reputation for truthfulness.
And this was one of the individuals that testified, that provided the witness testimony that I keep hearing about all over the place on social media, that there was evidence that he was a violent person.
Yes, Della Gray, his ex-wife and mother of his two older children, said that he was physically abusive, but interestingly enough, said she was scared of Robert, but during their divorce proceedings never reported any of this suspected abuse to authorities, and had a history of alcohol and drug abuse, and she lost custody of the children and never brought any of this out. She claimed in a 2003 trial during their divorce proceedings in the 1990s. So you kind of have to look at what they said at the time versus what they said when they had an agenda. So I think these witnesses, when they were looked at as to their motives and or were asked hard questions, tended to change their...
So to the best of your
testimony.
knowledge, no jury has ever found him guilty of any violent acts in the past that you're
No,
aware
he's
of?
been accused of it by people that had an axe to grind, but no evidence to substantiate it.
Real quick, as brief as you can, how would you characterize the effect on our criminal justice system if Robert is executed in the near future?
I think it would, I think if people really drilled down on the facts of this case and thought, given these facts, you can be executed against a standard of reasonable doubt, I think it would be horrifying.
Horrifying. The impact on our criminal justice system if he's executed without further due process being afforded him. Is that
Yes.
what you're saying?
Yes, I don't think he's had due process, and I don't think he's had a fair trial. And I think he should. And if at the end of all of this being presented, the decision is that he's guilty and should be executed, then that's a completely different story. But I think I think it should all be heard.
And I'll just, in closing, if you could maybe just, even one or two words if you can, and just tell us whether you think these are more fact or more opinion, because I know you've made a point to distinguish what you believe is fact in the case from opinion. Do you believe our junk science law, as intended by the legislature, has been appropriately applied in Mr. Roberson's case?
I do not.
How firmly do you feel about that?
I feel very strongly about that because the science has evolved and we have cutting-edge experts in this case that have taken very strong positions that the cause of death in this case, is more probable from medical complications than abuse.
And if I wrote down my notes, but just a quick confirmation, you firmly believe his due process rights have not been adhered to here, and how confident are you of that?
I'm very confident that due process can only be claimed if he is given an evidentiary hearing, which will lead to a new trial.
And if I wrote down correctly a minute ago, did I hear you correct that in this case, your personal opinion is that no crime has been committed whatsoever?
Based on the new evidence from the experts, I think no crime has been committed here.
Thank you, Doctor. Thank you, Chair. Thanks for being here.
Doctor, I appreciate your time, and you know what? I want to say this also. I appreciate your extensive research into the record in your preparation for your testimony here today. I appreciate you taking this with a great deal of seriousness, that we are evaluating what happened here. And for us to be able to evaluate that, we do need to rely on people that have done a deep dive into things. And I am grateful that you have taken the time, energy, and effort, you and your team, to do that deep dive, because you wouldn't be able to answer any of these questions if you hadn't have done that research.
Well, I have this knack for getting gigs where somebody does all the work and I get all the credit. And Stephanie Grenadier and her team at Merit TV and the Innocence Project and all other people, we've all worked very hard to figure this out. And most of it was done before I agreed to take on the case, because I had to figure out whether this was someone that I could passionately get behind.
Well, I certainly appreciate the time you put into it, and I think that that is certainly shown through in your testimony today.
Well, I appreciate the committee, and if I've kind of been doing this off the top of my head here as we've gone through this, and if I've misspoken or misstated any fact, it's all in the record here, and I'll correct it as if I check anything. If I got a date wrong or something like that, I'll certainly correct it. The record is what it is. The trial record is what it is. If I said 4 and meant 5 or whatever, I'll let the record speak for itself.
Sure.
Certainly what I've said is directionally correct.
Well, we certainly appreciate your time and taking so much of your day to be with us here today.
Well, thank all of you for taking this so seriously and speaking up for, this is not just about this man, it's about the process. And I hope it comes to a good outcome. Thank you for allowing me to speak here. It's an honor.
Thank you. This time, the chair calls John Grisham. All right, let's see. Bullet. Mr. Grisham, are you able to hear me?
I can hear you. Yes, can you hear me?
Okay, perfect. All right, and now we can actually see you as well. Sir, my name is Joe Moody. I'm the chair of this committee. I appreciate your accepting an invitation to offer testimony here today. So they certainly want to be respectful of your time. Before we start, I do have to, just as a matter of housekeeping, I have you listed as John Grisham, representing yourself today and testifying neutral on the item before us. Is that correct?
Yes, I guess I'm neutral. I don't feel too neutral, but I'll say neutral.
I'll be very clear. I don't anticipate you are very neutral in this matter whatsoever. But because there's no actual piece of legislation before us, you're technically, every witness that's testifying before us is neutral. So not to get into the mechanics of it, but I appreciate that. So with that being said, that all is correct?
Yes, that's all correct, yes.
All right, then I don't want to take too much time on the front end. I know members might have questions once we hear from your testimony. I certainly know that the committee is specifically interested in how you got involved in Mr. Roberson's case. Maybe some of your background, your experience as a trial lawyer, how you've interacted with other issues related to wrongful convictions, and ultimately got involved here, and anything else obviously that you want to offer. We'd appreciate that. Thank you, sir, and I'll turn it over to you.
Well, sure, Chair Joe Moody and members of the Committee on Criminal Jurisprudence, thanks for the invitation to be here and say a few words. I wish I could be there. It's much more effective, and Austin is one of my favorite cities. I apologize for not having prepared remarks. I'm on a book tour. I don't work that much, but I'm working this time of the year when I publish. So I've been on a lot of airplanes, and I just got to New York, and so I'll just ramble for a few minutes and then take some questions. I sort of know what you're doing because years ago I was a member of the House Judiciary Committee in the Mississippi House of Representatives, and I had that for 2 terms, and we had a number of committee hearings, as you do. I don't miss any of them, so I sort of know what you're going through, what you're doing. But none of those hearings back then were nearly as important as this one right here. So it's my honor to be here to speak for Robert Roberson. I'm also honored to be here to offer a few words of great admiration to this committee for your actions last week. You literally saved an innocent man's life. You took a bold stand against injustice at the precise moment when the courts and the leaders of the state seemed hell-bent on executing Robert. If not for you, Robert would be in his grave today. Your actions were creative, to say the least, fascinating, unique, courageous, bipartisan, and heroic. And we all watched in disbelief last Thursday night, not just in Texas, but around the country, around the world. I've talked to journalists in Europe the past few days doing book stuff, and they are fascinated by this case and by the actions that this committee took last week. So you chose to dig deep and to find the truth and recognize that Robert's life was worth fighting for. So I'm honored to be here to meet you. Robert doesn't need me to speak for himself. He has as you know by now, a great legal team made up of lawyers from Texas, Washington, and New York who have worked for many years to prove his innocence. One of those lawyers is a friend of mine in Washington, and about 8 months ago, he asked me to take a look at the case with the idea of perhaps writing an op-ed piece for a major newspaper. And I said, sure. I've been on the board of the Innocence Project in New York for a long, long time. And for the past 15 years or so, we have been more and more concerned about the shaken baby syndrome, shaken baby convictions. It's something we have studied. So I was somewhat familiar with that problem. And I said, sure, I'll take a look. My understanding is that last week you guys you committee members, got a lot of testimony about the medical and scientific evidence now available that proves that Nikki did not die because she was shaken to death by anyone. She died because of viral pneumonia, and we can prove that. I'm not a scientist. I'm not a doctor. I'm a lawyer, and I practiced criminal law in a small town in Mississippi for 10 years, and I had a lot of cases, a lot of clients, a lot of jury trials. I tried over 100 jury trials in 10 years, and I came to really respect the idea. We just believed in the idea of a fair trial. We still do. All Americans believe in the idea of a fair trial. We at least pay lip service to that. And I never had a client in 10 years I thought was wrongfully convicted. I knew the judges, the prosecutors, the policemen, the game was played fairly. And I just never thought about wrongful convictions until I'd written probably 20 books. And I saw this case that out of Oklahoma that fascinated me about a man my age who went to death row and came within 5 days of being executed. And so I wrote my first nonfiction book, The Innocent Man, published in 2006, about Ron Williamson and what happened to him. And it was a fascinating entry into the world of wrongful convictions. I have since become convinced that there are a lot of innocent people in prison. And that's why I do this work. That's why I get involved in these cases. As a lawyer, it always bothers me when I study a case like this and I realize how unfair the trial was. Because I've been in those courtrooms many times, and I know what it takes to have a fair trial. Robert's trial was grossly unfair. There was nothing aside from the junk science. The science was terrible. The science has been debunked and discredited and disproven now for the past 15 years. We know it's bad science. The science was terrible. The jury selection was awful. From the opening bell, the prosecutor was allowed to point a finger at Robert and call him a baby killer or whatever. That persisted throughout the trial until the closing argument. The absolute low point in the trial was when a ER nurse was allowed to testify that Nikki, who had been sick for her whole life, but really sick the week before she died, she'd had violent diarrhea, fevers, upset stomach, everything. A nurse was allowed to testify that she saw signs of sexual abuse looking at the child's anus, and there was no allegation of sexual abuse anywhere. It was not proven by the autopsy. There was nothing there. But she was allowed to testify. When I was, the defense lawyers, to their credit, objected. When I was a lawyer, that would have been grounds for an automatic mistrial. There's no way a prosecutor could get by with that in most courtrooms throughout the country. That's a mistrial. You stop right then and you say, stop it. And the jury goes home and you try again. That didn't happen. The judge waved it through. And the prosecutor was allowed to keep using the sexual abuse language even in his closing argument. The trial was a farce. It was a pathetic trial. And that's what I go back to in these cases. If we could go back and get a fair trial, and I think that's all Robert and his lawyers would love right now, is to get back into court, have the CCA declare a new trial. Let's go back to Palestine, Texas, to Anderson County, or maybe change venue, whatever, and let's have a legal team that Robert can have with as many lawyers as the prosecution, as many experts as the prosecution, as much money as the prosecution, put the jury in the box, and let's have a fair trial. That's all we're asking for. I'll stop rambling now. I just listened to Dr. Phil, and I'm astonished at the amount of research he and his staff put together in preparation. It was truly remarkable. I'm not that well versed in the case. I've come to it lately, but I'll try to answer any questions you may have.
Well, Mr. Grisham, I certainly appreciate that. I know you've looked at some of this from from a nationwide level, right? These wrongful convictions and some of that you've been able to delve into. Are there trends that you see, problems that emerge, things that would be helpful for the committee to understand that you've seen in your broad brushstrokes over this issue nationwide?
Sure. I mean, you start with junk science. With the Innocence Project, we have, I think our number is 370 or 375, around that, DNA exonerations in the past 30 years. These are clear-cut DNA, cases where they got the wrong guy. We were able to exonerate, which is not always easy, even with DNA testing that you pass. But in those cases where we have the exonerations, junk science is prevalent in half the cases. And it's excuse me, hang on. It's the bad analysis. It's like bite mark analysis, hair analysis, boot print analysis, arson analysis, and shaken baby. It's just more, there's so much junk science in our courtrooms and have been for the past 50 years. Unqualified experts giving opinions that are not driven by science. So junk science is a huge factor. There are many other factors that lead to wrongful convictions. Most of them are not present in Robert's case. And in some cases, you have everything. You have the lying jailhouse snitch, the paid informant, you have false confessions, you have incompetent defense lawyers. There's a long, sad list of reasons for wrongful convictions, but junk science is by far probably the biggest factor that we could do something about. And Texas has done a wonderful job with the commissions founded in 2005, with the law you passed in 2013, the amendment in 2015. Texas is at the forefront of cleaning up the forensics. I wish all states were doing that.
I appreciate it. I think that's we've seen a little bit of that. We've done some research into, in fact, we did some research after the death of Timothy Cole here in Texas on wrongful convictions and what kind of some of the common threads were in those cases, so that we could start to address them. Obviously, junk science was addressed in particular in this provision, and so I think those are some very good points that everybody can take forward. I do want to make sure, and I want to respect your time. I know we've got a limited time to visit with you, but I want to make sure if there's anybody have questions, I don't want to monopolize the short time that we have to visit with you. Anybody down here? No? Over here. Then I will, well, actually, I have a lot I want to go into about DNA cases. I want to be respectful of your time, to make sure that, oh, sorry. Yes. Sorry, I do have a question. Chairman Leach?
Yeah, thank you, Chairman Moody. Mr. Grisham, thank you for joining us. Let me just ask you one question. And I've read a number of your books, and Mr. Grisham actually decided to go to law school myself and become a lawyer, largely because of so much of what I've learned and gleaned about the practice of law and the importance of honest and good and knowledgeable and passionate lawyers on both sides. Can I just ask you, as someone who sees the legal landscape nationwide, and you've written about, you've researched, you know a lot about these cases, you've committed yourself to the wrongful convictions and making those right. What do you think it's going to take, understanding where we are right now in this case? What if you were us and you're trying to make the case to the other branches of government to give Mr. Roberson a new trial? What would you focus on? What to you are the most troubling aspects of this case? And what's it going to take, in your opinion, to get to achieve justice for Mr. Roberson?
Well, I hope it's not a disaster. I hope it doesn't take a wrongful execution. We do not, to my knowledge, we do not yet have a case involving clear DNA proof that we've killed the wrong person. The Death Penalty Information Center tracks all types of data wrongful convictions and for death penalty cases, and they list about, on their website, they list about 20 cases of probable innocence. Okay, half of them are from Texas. These are probable. You can't really prove them. Okay, they're close. There's no DNA case. And so years ago, I wrote a book about the premise was, what are we going to do as a nation when we wake up one day and we know by clear DNA proof we just killed the wrong guy? That's a great question. I can't answer it. I don't know. I'm afraid we won't do much at all. I am encouraged by the declining number of death verdicts around the country, the declining number of executions, and the number of states that are outlawing the death penalty. That's a good sign. I tell my friends all the time, people who, I grew up in supporting the death penalty because I grew up, in Mississippi, Southern Baptist and all that. I tell people all the time who support the death penalty, you can't support this death penalty, but I can show you how to make one fair if you want to make it fair for everybody. And keep in mind, most capital murder defendants are guilty. The crimes are horrible. But there are too many innocent ones.
Mr. Grisham, would you agree though? And that's one area on which you and I might we definitely do disagree, because I myself am a death penalty supporter in the most heinous cases, much like Dr. Phil described earlier. But like Dr. Phil, and I think like you, and hopefully all of us, we can agree that the worst thing we could do for our criminal justice system is to execute someone who's potentially innocent. Certainly someone who's definitely innocent, but even someone who is potentially innocent with such substantial questions in a case such as this. Wouldn't you agree that pushing the pause button and going back and simply affording a new trial in front of an unbiased trier of fact so all of the evidence can be heard, wouldn't you agree that is the only right option?
Yes, especially in a case like this one, where the science has changed. Now, not all cases have this. Not all cases have, science has changed so much, or science has been discredited or proven to be not correct. But when you have a case like this where the science is just wrong, okay, it was wrong 30, 40, 50 years ago when it was first developed, sure, you have to go back to a fair trial. Let's do it all over again. Well, what's the hurry?
Right. Thank you, Mr. Grisham. Appreciate your time today.
Thank you.
And before I let you go, I think about this because DNA becomes kind of the gold standard in exonerations. I mean, when we have actual innocence cases in Texas, that's kind of, we require that to be part of the combination of factors that's considered. If we don't have that, then you don't get to the actual innocence piece. Like, we feel so strongly about DNA evidence and its reliability. That's the weight we give it. But in many of those cases, in fact, I'll just ask you, I mean, you've looked at cases that were later ended in exonerations via DNA evidence. In those cases, prior to the DNA exonerating that individual, weren't there people crying out loud that this individual is still guilty, they're guilty of sin, they did this, they're adamant about the guilt of this individual, and then later DNA evidence comes out and exonerates them?
Happens all the time. And we worship DNA. However, in most murder cases, there's no DNA. There's no body fluids. There's nothing left behind it. So you have to go back to other forensics, ballistics, or identification, or whatever. Most cases don't have DNA testing available. So those are much more difficult cases to exonerate than DNA. DNA has been a lifesaver, and the police are using DNA more and more to solve crimes, to their credit.
Well, and I think you made the point I was trying to make, which is, if people will shout from the rafters that this person's still guilty over and over, and then DNA later exonerates them, but DNA is such a limited number of cases, it reasons to follow that in non-DNA cases, there are people still shouting that this person's still guilty, but in fact, they probably are not. I mean, it has to, those have to correlate. They have to correspond. We have such rare opportunity to have DNA evidence, which we all have a great deal of respect for, but all of these other cases that you just stated don't have that. And so, that's where a lot of this type of procedural law comes in to help. alleviate those gaps where we don't have the gold standard like DNA. So I'm certainly grateful for your time, and I want to make sure none of the other members have questions. Want to be respectful of your calendar. And do we have any more? No, Mr. Grisham, thank you so much, and thank you for taking the time.
Thank you very much.
Thank you. Chair now calls Terry Compton. Sorry. She'll be. Good afternoon, Ms. Compton.
Good afternoon.
Let's do this. These are fairly directional mics, so for us to be able to hear you,
Bit
you gotta,
closer?
yeah, if you can actually pull the whole microphone up to you. That'll work real well.
Like that?
Yeah, that'll be perfect. Before I have you testify, just want to make sure I have this correct. Your name is Terry Compton.
Yes.
You're here testifying on behalf of yourself, correct?
Yes.
Okay, and you checked that you are neutral on the topic today.
Yes.
Okay. Do you have prepared remarks for the committee today?
Yes.
And then, you know what? I'm going to let you start with that, and then we'll ask some follow-up questions if we have them.
Okay.
Thank you for being here. Let me ask you this. When did you get into Austin?
About 11:30,
And where'd you come from?
Palestine, Texas.
Okay. Well, I want to say thank you for taking the time to be here with us today, and I will let you give your comment. Thank you.
Okay, thank you. Good afternoon, everyone. It is a great honor to be here testifying before this committee. My name is Terry Compton. I was one of the 12 jurors on the case of Robert Roberson's trial, and I took that position very seriously. Everything that was presented to us was all about shaken baby syndrome. That is what our decision was based on. Nothing else was ever mentioned or presented to us to consider. If it had been told to us, I would have had a different opinion, and I would have found him not guilty.
I, first of all, want to thank you for being here. And I know it was not an easy thing for you to get here. I know you have a lot of obligations back home. So I'm grateful for the time you spent. I know that Mr. Harrison had some questions for you. And I know some of the other members have questions for you, if that's okay. But I'm going to allow him to ask you questions first, if that's okay with you.
Yes, sir.
Okay. Representative Harrison.
Thank you, Chairman. And Terry, thank you for being here. You drove a little ways to get here. And,
Yeah.
My understanding is you've got a pretty busy life on the home front. Tell us just a couple sentences about that.
Yes, sir. I raised 3 kids of my own, and I have multiple grandkids, and then I ended up having to adopt my 4 youngest grandkids, and I am now raising them. We adopted them, me and my husband. My husband is 86 years old and has multiple heart problems and stuff. He has an LVAD on his heart to where his heart is being pumped off of batteries. I am 69, so having to take in a 13-year-old, 11-year-old, a 7-year-old, and a 5-year-old straight. The younger 2 we brought home straight from the hospital. Needless to say, it is a very life-changing experience.
Yeah, without a doubt, and God bless you and him. So you and your 86-year-old husband are raising 4 young children right
Yes.
now. And you live in Palestine, but you took the time to drive down here. Did your husband come with you, or is it just you?
He was going to, but he didn't feel very good today, so I brought my daughter instead with me.
Wonderful. Well, thank you for making being here a priority today.
It was
I think-
very much a
I
priority
think
to
it's
me.
important for the committee to hear your perspective on this, because you were, or maybe I'll ask it as a question. You mentioned this in your testimony. You were on the original jury that convicted Robert Roberson. Is that right?
Yes, sir.
And one of the reasons I think it's so important we hear from you is because I hear a lot of people saying right now, and that we've got to trust the jury in this case. And you were one of them, and the jury convicted him of murder. And you were one of the jurors that cast a vote to convict him of murder. Is that right?
Yes, sir.
So it's really important we hear from you. How, and I've got several questions, so as short as you can kind of make this, what made you feel that he was guilty of murder that led you to cast that vote of guilt for him?
Because Nikki was dead, and from what we were told about the bacon shaken baby syndrome and showing the pictures of her brain with all the bleeding up in her brain, there was no other explanation that was given to us of anything else that could have happened to her.
Yeah, so it would be fair to say, from your perspective as a juror, this case was about shaken baby syndrome.
That was the only thing that was discussed or told to us that it was about.
That's the only thing.
Only thing. Nothing else was ever told to us, ever discussed with us. Any other options was never told to
From the
us.
start of the trial, the middle of the trial, and just to be clear, you were there for the guilt phase, and were you also there for the sentencing phase as well?
Yes, sir, I was there through it all.
And for the whole time,
The whole thing.
whole time,
Whole
shaken
time.
baby syndrome,
Yes.
Nothing-
Nothing else was ever told to us.
nothing else. So I'm going to ask you a question anyway, just because it's written down. I want to ask it to you. Were you told anything about this little girl, Nikki, being beaten?
No. In the jury room, that was nothing we ever discussed. The only thing we ever discussed in the jury room was the shaken baby syndrome.
So you heard nothing about Nikki being beaten as an explanation for what you witnessed in the jury room?
No.
You never heard witness testimony or arguments from the prosecution that her father, Robert, or anybody else had struck Nikki, or that blows or hits to the head by somebody is how she ended up in that case in the hospital?
No.
Did you hear any discussion of sexual abuse in the trial at all at any time?
Yes.
Did you have to vote on that? Was he ultimately charged of sexual
No.
abuse? But to the best of your recollections, you and the jury, are you testifying here that you and all of your jurors heard allegations, and maybe I'll ask this, were they graphic allegations that you heard?
Yes, sir.
Yeah. Did you ever see any witness or any evidence to corroborate those things that all of you jurors were told about allegations of sexual abuse?
No, all it was, what we were told, there was a nurse that testified. She testified that she was a certified sane RN, and that she had found these tears and everything else, and that is what we were told. She told this, and it was brought up several times, but then when it came time toward the end of the trial, they disappeared. They were never
The charges?
Charges. They were never charged. We never had any discussion of them in the jury room. There was no other type of discussion about it in any size, shape, or form. And then come to find out, she was not even a certified sane nurse.
And forgive me for the graphic nature of this, but you were told of sexual abuse to such an extreme that tearing was implicated and involved, and told to you, the jurors. The person who said this represented a certain certification that upon cross-examination they had to admit they were not even certified to be discussing the matter. Is that right?
Yes.
Is there any reason for you to believe that he was guilty of sexually abusing Nikki or any other child?
No. Except for what she said.
So this case was a shaken baby syndrome case, start, middle to end. Is that your recollection?
Yes, sir. And also to my recollection, I believe the prosecution even got either it was a teddy bear or a baby doll and got it up and shook it to demonstrate to us what shaken baby syndrome was.
I'm really glad you mentioned that. Let's talk about that for a second. Because what is being thrown around right now, and we'll get to this more in a minute, people keep saying, the state right now, to defend the execution, they are saying that Nikki was beaten several times on the head. And you just testified a second ago, if I heard you right, you never heard anything about that.
No, sir.
Do you have any recollection of multiple impact sites that Nikki had been beaten on multiple parts of her head?
No, sir. The only thing that maybe had been mentioned was she might have had a small bruise from where she fell out of bed.
Yeah. Were there any photos or discussions that you saw, or any evidence you saw, that made you think that anything of substance, and certainly of sufficient force to kill a baby or a 2-year-old, was on her head? Did you see any photos of severe bruising on her faces at all?
No.
In the photos you saw, did Nikki look like she had been beaten?
No.
I want to go to this teddy bear. Did you say it was a teddy bear?
I don't remember if it's a teddy bear or a baby doll or a child's baby doll or something.
Help me understand this. Why would a baby doll or a teddy bear be brought into the courtroom? What were they doing with it?
I think they were trying to emphasize the extent of what the shaking baby syndrome was and how violently he had shook it.
Can you describe to us, okay, so that was the point. What did they do with the doll or with the teddy bear? Can you just describe what you saw them doing with the doll?
They grabbed it by its arms like this, and they just violently shake, and just tried to give us an example of what the shaking consisted of.
And they did this, did they do this because they wanted the jury to understand what could have explained their theory for what was going on inside of her brain and what they believed happened to Nikki? So was the doll kind of like a substitute for Nikki?
They were trying to make it a substitute for Nikki.
Is that what you believe? You were seeing
That's
them
what I
simulate what
believed.
they believed
Yes.
happened to her?
Yes, sir.
Okay. Did they ever simulate the doll being hit in the head with anything?
No.
Did they ever simulate the doll being hit in the head by Robert?
No.
Did they ever simulate the doll being thrown against anything?
No.
Did they demonstrate the doll being hit in the head in any way?
No.
So the only thing you saw that simulation with that doll on was being shaken. Is that right, or is that
That is
wrong?
correct.
Do you remember if the defense counsel objected to any of this at the time?
No, sir.
Well, you don't recall, or they did?
No, he didn't.
Okay.
Did they talk about, if that was the case, was there any discussion about damage to other parts of Nikki? Because, if you're shaken like that, was there any discussion about other injuries that might be intuitive if that were to happen? For example, fractures or neck tissue damage?
No, sir.
Nothing about a neck damage or any other part of her body?
No, sir.
Okay. Do you have, based on what you heard, and you sat through the whole trial, do you have any reason to believe that Robert was a violent person? Is there anything that stuck in your mind about that, based on everything you heard?
No, sir.
Were there any alternatives that you, the jury, any alternative explanations, I should say, to what could have explained what you were seeing from the medical evidence regarding Nikki, other than that she had been shaken?
No, sir.
And I jotted this down, but during your testimony, I want to make sure I heard it right, or maybe it was during one of your answers a second ago. You mentioned something about the deliberations in the jury room, and you were in there deliberating with your jurors.
Yes, sir.
What were you discussing when you were in the jury room deliberating with your jurors?
The only thing that we would basically discuss was the shaking of the baby and the head injuries with the bleeding and stuff, that they showed us pictures for where they had cut her skin away from her brain. where we could actually see the whole shape and the bleeding on her brain. And they sent those pictures around for all of us to look at. And that's what we would be looking at, was all the bleeding in her brain. And that's what they told us had been done from the shaking so violently, it had burst those blood vessels.
And I want to peel at that. I assume the pictures were rather hard
Graphic,
to
yes.
view. And they were after the autopsy?
Yes.
Okay.
Or during, after.
During or after, but, okay. Was there anything else that you can recall, you and your fellow jurors, discussing when you were in deliberations in the jury room, other than, was this child shaken to death?
No, sir.
You'd have no recollections of anything else discussing this child being beat, hit, or otherwise abused?
No.
Okay. I want to go to the medical history now, because that has come up a lot in this case. What did you know about her case? What did you know about her medical history? I'll phrase it that way.
The only thing that we were told as jurors is that she had been sick, that Robert had taken her to her pediatrician, I think earlier in the week, and he had given her Finnegan. A couple of days later, she had been running a high fever. I believe we were told about 104. He had taken her to the emergency room. Again, they had given her some Finnegan with cough syrup in it, codeine. And he'd taken her back home again. And then the next thing we were told is when she had rolled off the bed, she, I guess, was okay. And he put her back in bed with him. He woke up again. She was unresponsive. And that's when he took her to the emergency room.
So prior to basically starting 48 hours out from her death, did you have any knowledge of her medical history?
No.
And would you characterize, because I don't want to misrepresent what you just testified to there, but in the days leading up, so the 48 hours roughly, you knew about it. There was a doctor visit, hospital visit. And by the way, was it your understanding he was the one taking her to get medical care?
Yes.
On multiple occasions?
Yes.
In the last 48 hours of her life?
Yes, sir.
Okay. Was there anything that you heard at trial that led you to believe that she was severely sick?
No. I just thought, what I took it as being is that I thought she basically had the cold, running a high fever. I thought she was probably pretty sick, but nobody was ever figuring out what was wrong with her.
Okay. But was there a lot of discussion in trial about her extensive medical history?
No.
Okay. I would like to ask you a few things because I think it's really important. I want to ask you a few things that we now know, and I would like to hear you just let us know if you were aware of this type of medical history for Nikki. Were you aware that there was a CAT scan done that showed only a single minor impact site to the head that had only a small amount of breathing? Did you ever see this CAT scan?
No, sir.
Were you aware, or did the jury see, CAT scans and autopsy photographs that showed only a single impact site of the head with only a small amount of subdural blood and brain swelling that would have been, in fact, completely consistent with a short fall?
No, sir.
Okay. Were you aware, was the jury aware of a post-mortem toxicology report that the medical examiner, Dr. Irvin, did not consider that showed she had toxic quantities of Finnegan and Finnegan with codeine in her bloodstream at the time that the autopsy was performed?
No, sir.
I'm going to take a quick tangent here because these drugs now, are you aware that they now carry what's called an FDA black box label?
Yes, sir, because I know the pharmacy I go to won't even carry it these days.
Yep. That wasn't the case back then. And I'm going to read just a couple statements to make sure everyone understands what we're talking about when we're talking about FDA black box warnings, because I want to know if you knew this at the time y'all made your decision. Were you aware at that time, in 2002, that Finnegan tablets and suppositories may lead to, quote, potentially fatal respiratory depression?
No, not then.
Were you aware that Finnegan tablets and suppositories in patients with compromised respiratory function, such as sleep apnea, yes, should be avoided.
No, sir, not then.
Were you aware that caution is now this is the official, this is from the FDA, caution should be exercised when administering Finnegan tablets and suppositories to pediatric patients 2 years of age and older because of the potential for fatal respiratory depression?
No, not then.
And were you aware then that excessively large doses of antihistamines, including Finnegan tablets and suppositories in pediatric patients, quote, may cause sudden death?
No, not then.
Yeah. Nikki had been prescribed these drugs, these cough syrups, that do metabolize into morphine. And this was in conjunction with the fact that she had a severe respiratory infection. Were you aware that she had a severe respiratory infection?
No, sir.
Okay. Are you aware of the evidence that has established that Nikki's heart, after she was admitted, was resuscitated even after her brain had already become brain dead? It's called non-perfused. But that blood thereafter, over the course of 2 days, was being pumped through her resuscitated heart to her brain, but it didn't have the ability to end the brain. Did you know about this at all? And did anybody ever tell you that this could have possibly explained all the blood that was up there?
No, sir. From what we were basically under the understanding of, that when she got to the emergency room, she died sometime later that day. We were never told she was put on life support or anything like that, and actually survived for 2 more days.
So really quick, so I want to pull at this. You testified you saw these autopsy photos where the dura had been pulled back, and you saw all of the horrific blood up there, and you were told that was a result from shaking, but you were never told that for 2 days they had been pumping through her artificially stimulated heart blood up into her head.
No, sir.
Okay. Are you aware that there's evidence that after Nikki was moved to Children's Hospital in Dallas, she was receiving epinephrine and 3 other drugs that stimulate blood flow and raised her pulse to over 200, adding to the blood flowing in and under the scalp and accumulating in the subdural space, yet it was unable to enter the brain? Did you know about that?
No, sir. Like I said, I thought she had died there at Palestine Hospital later that day.
Were you aware that when the medical examiner, Dr. Irvin, conducted an autopsy, she observed an accumulation of subdural blood, but that the medical examiner made no attempt to reconstruct past events to assess how that accumulation in the subdural space of her brain had occurred during Nikki's hospitalization, and that despite expert medical witness to the testimony, she determined that that blood was a sign of multiple impact sites, even though that's not consistent with anything that's outside of the exterior of her brain. Were you aware of any of this?
No, sir.
Okay. Are you aware of the evidence that is now well established that Nikki, who had been very ill for most of her life, had high fevers during her last week, and you might have mentioned you knew about the fever? Are you aware that she had an unidentified respiratory infection that included double pneumonia, both viral and bacterial? Were you aware of this?
No, sir.
Were you aware that the pneumonia had advanced to the point of sepsis?
No, sir.
Were you aware of her having any blood clotting conditions or disorders that might have impacted how well she or how easily she bruised, and that could have impacted brain activity subcutaneously?
No, sir.
Okay. Were you aware of the evidence and the witness testimony that I have heard directly from a forensic lung experts that testified that her pneumonia had progressed so great over the period of probably 3 weeks that he didn't understand how at the time of death her lungs would have been capable of even absorbing enough oxygen to maintain life?
No, sir.
If you had known that, would that have made a difference in how you voted in this case?
Yes, sir.
How big of a difference?
Very much difference. I would have found him not guilty.
In 2002, were you aware that Mr. Roberson had autism?
I was not aware of it in 2003, the day of the
The
year
trial
of
was
the
2003,
trial.
that's right. And this is important because I have had law enforcement testify here to this committee that he had a really flat affect. How would you describe his demeanor at trial, and did that have any impact on your views of his guilt or innocence?
It didn't have a whole lot, but I'm going to say it probably did have some. He just basically sat at the table, didn't look at us, didn't pay how much attention, just basically stared more or less straight ahead.
Did you find that odd?
It was kind of odd.
Would it have struck you as less odd if you knew he was had been diagnosed as being
It
on the
probably
autism
would have,
spectrum?
because I would have explained what his behavior was.
Do you remember, going back to his attorney at the time, do you remember his attorney, was he arguing more that Robert was innocent of any crime, or was his focus more on what type of punishment he should receive? How would you talk about his defense attorney? How would you describe it?
I thought he was more worried about what punishment he was going to receive. I think he more or less accepted that he was guilty of the shaken baby syndrome, and he was just more worried to try to get him the lesser punishments.
Yeah. Did he ever, the whole trial, did the defense attorney ever present you with other explanations for the shaken baby syndrome triad, the swelling brain, the retinal hemorrhaging, and the subdural bleeding? Did he give you any other explanation that could have explained those three things?
No, sir, that's what made it so, more or less, this is what it is, because he gave us no other options or any other type of options that we could have considered.
Would it have made any difference to you if at the time, if you had known that there are many other things that can result in all three of those triad of symptoms?
Yes, it would have. It gave me something else to have considered.
So you considered nothing else?
Nothing else, because nothing else was presented to us.
So you saw the three symptoms, shaken baby syndrome, the prosecution said it, and the defense attorney said it. Is that right?
That's right.
Okay. So just one last time, nothing you and I just got done discussing, all that medical evidence was not presented to the jury, and you were not deliberating on that in the deliberation chambers?
No, sir.
Tell me about your history on this in recent times. Are you aware that he had an execution date set in the past few months?
Yes.
How did you hear about that?
I actually read it on my phone, because I keep a bunch of news feeds and stuff like that, because I like to keep informed of what's going on.
So you heard about it in the news?
Mm-hmm.
Okay.
I've also kept up, when he's had different hearings at different things it comes across, and I guess because I was on that trial, I have always kept up with things that has been going on.
So you've paid attention to it over the last 20 years?
Off and on, yes.
Yeah. What was your reaction when you heard that they had set a new execution date for him?
It kind of got my interest more so then. But then when I started reading about all these other things coming out about the pneumonia and the sleep apnea and the double pneumonia and all this extra stuff that has just now started to be coming out that I've read about, or maybe it's been out but I just now recently read about, it got me even more thinking, and I started thinking back about all the things that I knew about that went on in the trial, and I just realized, and I just finally came to the conclusion, he was an innocent man. And I just, in good conscience, I could not live with myself thinking that I had a hand in putting an innocent man to death.
Wow. So this had to be emotional for you. When you came to that realization, what kind of things did you do? Did you have discussion with your husband or other family members about this? How was your emotional reaction?
I had a very big discussion with my husband and with another friend of mine. And there would be times that I'd be talking about it with my husband that I would literally start crying about it, because I felt that emotional about it.
What made you so emotional that you started crying?
Because I just couldn't think about killing a man, and that's how I looked at it. My decision 21 years ago was getting ready to come to realization, and I literally, in my eyes, was killing a man that I knew was innocent, and I was going to have to live with that.
This must have weighed on you over the last few months.
Very much.
why, for what it's worth, not a question, but just a statement. I'm confident I'm confident in this. I can speak for everybody up here. We're all humans, and nobody would expect you to be judged on 2024 knowledge in 2002, 2003. Okay. You are only responsible for what you knew at the time.
Yes.
I need to bring this back to very present day because we've had a lot of developments in the last few hours, last few days, that I would like your take on
Okay.
as someone who was on the jury. When this committee issued our subpoena, something that just as a matter of fact, if we had not done, he almost certainly would be dead right now. There was a lot of litigation that has started, a lot of arguments. And the government, the state, and in this case the Attorney General's office, made an argument on the day that we issued the subpoena, I can't remember if it was that day or the next day. They began arguing that Robert Roberson's case was not a shaken baby case. I would like to read you a couple quotes.
Okay.
This is from somebody in the office of the Attorney General. The evidence supports the fact that there were multiple blunt force impacts to the child's head. How would you respond to that claim?
I would like to know where they got their information from, because that is not true.
Let me get rid of the rest of this one quote. And there was a history of abuse from this particular inmate against this child.
Again, I would like to know where they're getting their information from, because that is nothing that was ever brought up during the trial or at any other time.
There's more to this quote. Quote, shaken baby syndrome just doesn't play a role in this case. It's just not the central feature of this case.
Me being at the trial and in the jury area and the jury room, that is all that this case was based on, was shaken baby syndrome. And even the prosecution's star witnesses that they would have brought up, psychologists, doctors, all of this, the only thing that they would discuss in their testimonies and all of this was shaken baby syndrome.
Yeah. I'm going to hold something up right now. I don't know if you can read it. So I'm going to read you the first half of this, all right?
I have bad eyes, so you're going to have to get something over here closer.
That's okay. I can read this to you.
Okay.
Actually, no, I have a copy. Can she be provided a copy of that? All right. This is from an official pleading from the Office of the Attorney General when he was asking the Supreme Court to reconsider our subpoena. I'm going to read the first part of this. And before I do that, I'm going to ask you a question you've already answered. Mm-hmm. You were a juror on this case.
Yes, sir.
Okay, I'm going to read the first half of this. A Texas jury convicts Roberson of beating his 2-year-old daughter to death.
Not
Ma'am,
true.
Is that what you convicted Robert of over 20 years ago?
No, sir.
How sure are you?
100% sure.
Who would know better, you or somebody in the Office of the Attorney General right now?
Me, because I was in the jury. I was the jury, and I'm the one of them that made that conviction of shaken baby syndrome.
How does it make you feel seeing these statements by the government right now as somebody who lived through every day of the trial?
It has pissed me off very much.
I'm going to wrap up now because I'm certain my colleagues have questions.
And also, too, it has pissed me off about our prosecutors in Anderson County, because I heard they testified that this is what it was. And personally, the prosecutors now was not the prosecutors back when the trial went on. Prosecutor back then was Doug Lowe, and his assistant was Mark Calhoun. So how do they even know what went on?
And I think there was at least widespread sentiment up here when the district attorney testified that she did not come prepared, and nor did she demonstrate even a basic level of knowledge of the facts in this case. So I'd like to wrap up here and let folks...
I have to say, she is not very well thought of by a lot of people in Palestine, because she basically has no knowledge about her job most of the time.
Okay. All right. I want to summarize a couple things, a couple very quick closing questions, and move on to my
and
colleagues.
I will tell you one other thing.
Yes, ma'am.
To help your committee.
Yes.
Palestine Medical Regional Center is not the best hospital to take your kids to get anything done. They have a bad history of misdiagnosing people and everything else. And so that does not surprise me that they probably misdiagnosed Nikki and did not get her the proper treatment and do the proper treatments when they should have.
Thank you for sharing that. That is helpful as we consider all the aspects of this case. Thank you.
And
very
I know
much.
that for a fact. My husband fell off our back deck. They took him into the emergency room. They did a CAT scan of his head and his neck. They put him in for dehydration. He spent 4 days there. Had him up walking around doing physical therapy. I got him, picked him up. He's talking all nut crazy to me when I got him. I called our family doctor. They told me to take him to Tyler. I did. They did another CAT scan of his head and neck. Come to find out he had a fractured neck. I got the CAT scan from the hospital. I took it to our primary care doctor. He's seen the fracture. I called the hospital and started raising Cain with them. They sent it out to a third party. 3 weeks later, I get a phone call from the third party. They said in the CAT scan from the hospital, he had a fractured neck and wanted to make sure I had gotten him and taken him to get some help. That is how good our hospital is at looking at CAT scans, diagnosing, and taking proper treatment care.
And the care and the attention to detail and the maintenance of records certainly played a central role
That's
in
what
this
I'm
case.
saying.
So thank you
That's
for
how
sharing
come I'm
that
saying.
perspective. Okay, I just want to summarize a couple things, so just
Okay.
tell me if I'm right or wrong, because I
Okay.
don't want to mischaracterize anything you said here. I'm going to run through a few things real quick,
Okay.
and then we'll let some other folks have a chance to talk to you. You were a juror the entirety of the trial, both guilt and sentencing phase, correct?
Yes, sir.
This was, according to your testimony, a shaken baby case, and only a shaken baby case, is that right?
Yes, sir.
You never believed and still do not believe that Nikki was beaten by anybody whatsoever. Is that correct or not correct?
Correct.
You did, however, hear discussions, very graphic discussions, of sexual abuse of Nikki.
Yes.
And the discussions involved her father being the person that did it.
Yes.
But they were completely unsubstantiated, and the charge was ultimately dropped. Is that correct?
I don't think there ever was a charge of sexual assault.
Okay. But nonetheless, you heard these unsubstantiated, graphic claims in the jury. You and your fellow jurors heard this,
Yes, sir.
and you never voted on it.
No.
You are now rejecting here today the new claim that Nikki was, quote, beaten to death.
Yes.
You knew very little about her relevant medical history at the time of the trial, and if you knew her full history, that would have mattered a lot to you. Is that correct?
100%.
And you're telling me that his defense attorney for the entirety of the trial never gave you one single possible or plausible explanation for what could have caused the 3 symptoms that they were telling you was shaken baby syndrome. Is that correct?
Correct.
And you never heard a single argument or any bit of evidence that this was not shaken baby syndrome.
No.
All right, 3 questions. Did the jury hear everything that you needed to hear to make a correct decision in this case?
With the evidence now, no.
Knowing what you know now, did the jury get it right?
No.
Knowing what you know now, do you believe Robert Roberson murdered his daughter, Nikki?
No.
How strongly do you feel about that?
100%.
Thank you for your courage. Thank you for your time. Thank you, Chairman.
Mr. Harrison, thank you. Ms. Compton, I'm going to ask other members if they have questions for you. I just want to follow up on one thing, and more of a statement than a question. It takes a lot to confront a very challenging situation like this. I know it does not make you feel comfortable that Robert's sitting on death row, given what you know today. And there are people, when they're confronted by difficult things, they put their head in the sand because it's easier than dealing with it. And I'm grateful for you making the trip here and telling us your feelings. And it's okay to say you're pissed if you are, because that's what we wanted to hear. Because the exact reason that this legislature created a law to go back and make sure that someone got a fair trial is because we don't get to get back inside the head of the jurors. We want to protect them after the fact, just in case something happened that was a mistake. But the courts have refused to do that. And your testimony here today gives us the opportunity to get inside that jury room, to understand the way you think and to understand the way that you feel. You are exactly correct about your analysis here. And your testimony is exactly what we needed to know that our law is not working. So I want to tell you, I am grateful for you coming here on a day's notice to talk to us. That's important, not just to Robert, not just to this committee. It's important to the entire state of Texas and the justice system that we have. It is going to impact so many lives that you will never interact with. And I want to say thank you for that. Members, do we have any questions for Ms. Compton otherwise? Yes, Mr. Cook. Vice Chair Cook, sorry.
Thank you. Thank you for your testimony today. Thank you for coming to Austin, and just wanted to ask you a couple of questions. And so earlier you talked about the either the baby doll or the teddy bear that was being shaken. And so that was an example of where the prosecution was showing you what happened in this case, right?
Right.
Yeah. So if the court were to, if the judge would have excluded any testimony or any evidence being presented at the trial that had nothing to do, basically everything that had to do with shaken baby syndrome would be eliminated. So if I can just ask you to kind of just erase that from your memory. What other evidence did you hear of any type of physical abuse?
None.
Okay. And with regard to the sexual abuse, it was discussed at the beginning of the trial, is that correct?
Correct.
Okay. Would it be impossible for you to remove that from your mind? I mean, as you said here 20-something years later, you still remember him being accused of sexually assaulting his 2-year-old daughter, correct?
Yes.
Right. So it's fair to say that it would have been impossible for you to have considered it while you were sitting in the jury room. You would have had that knowledge.
We had it in our minds, and I think that probably we didn't discuss it per se, but I think it was in the back of every juror's mind that happened.
Let me ask it another way. If he had been previously convicted prior to this incident, if he had been previously convicted of sexually assaulting a minor, would that have impacted, would it be impossible for you to have not considered that in evaluating the evidence?
No, it probably would have weighed heavy.
Okay, thank you.
Members, do we have any other questions? Yes, Ms. Morales.
Thank you so much. Your testimony today is incredibly powerful, and it's going to create positive change in our state. One thing that has stuck out with all of the testimony that we've heard today is that the child was given 2 very strong medications. I've taken both of those medications in my lifetime, and I don't take them now because they're very, very strong. And it's interesting what you said about the medical community there in Palestine. So I guess my question to you is, during that time of the trial, did it ever occur to you, or did it ever stand out in your mind that these medications were very, very strong and that maybe they shouldn't have been prescribed to a child? And to be honest with you, I don't know how I felt about those medications during those years, because medicine has evolved during the last 20 years, but I'm just curious if that, if you questioned that at all at the time of the trial.
No, I don't think we did, because that many years ago, it was such a common drug that pediatricians or doctors, prescribed for costs and this type of thing back in those days. I know previous down the road, they have changed what they do about all of that. But back in those days, I don't think it was something that we really considered it being too out of line of that being prescribed for a 2-year-old.
Wow, and to have them both at the same time, it
Right.
just...
We just didn't, it's not
couldn't
something we
imagine.
really thought about.
Thank you so much.
All right, Ms. Compton, appreciate your time and thank you for being here. I don't think we have no further questions for you at this time. If we had other questions later down the road, do you mind if we reach out to you?
No, sir.
Okay.
I'm free anytime.
All right. Thank you.
And thank you all for having me and listening to me, and hopefully we'll get this right the next time around.
That's the point. Good luck with those grandbabies.
It's hard starting over.
Chair calls the Honorable Elsa Alcala. Judge, can you hear me? Let's see. Oh, there it is. Judge, are you able to hear me yet? That says it's connecting up there. Oh, there, I think. How about now, Judge?
Oh, I can hear you,
There
yes.
we are. Okay. Sorry, technical difficulties. Judge, good to see you again,
You too.
even if only virtually. Before we get started, and I know we've had you before the committee before, back in 2017, if I remember correctly. I have you registered as Elsa Alcala, testifying on behalf of yourself and testifying neutrally on the topic today.
Yes, sir.
Okay, great. And I'm gonna allow you to make your comments, and talk about some of your background. Some of the folks up here may not know you, have any, may not understand your background, so I think it'd be worthwhile to spend a little bit of time on that. But were you a judge on the Court of Criminal Appeals in 2014 or 2013, that time frame, when Article 11.073 became law in Texas?
Yes, sir.
Okay, and how long did you serve on the Court of Criminal Appeals?
I was on the Court of Criminal Appeals from 2011 to 2018, so for about 7.5 years.
Okay, so you saw the law prior to the creation of this particular relief, and then you saw the application of it after it became law, correct?
Correct.
Okay. I'm going to turn it over to you for your testimony. I know that I'll have some questions that I'd like to ask you in follow-up to that, and I don't know if the members will as well, but want to give you the floor. Thank you, Judge, for being here.
Thank you so much for inviting me, and thank you so much for understanding about my need to testify virtually. I'm in Colorado, and I tried to get a flight over there, and I just wasn't able to make the arrangements the way I'd hoped. But I appreciate this committee so much for taking the time to hear all of the testimony and for your extraordinary intervention last week. It was peculiar, certainly, but I think it was greatly appreciated by those of us who are so committed to the cause of innocence. And I have the utmost respect for everybody on this committee for taking those steps that you did last week. What I'd like to do is make 3 points that focus on the law. We've had a lot of testimony that talked about the science and the medical issues involved in this case, but I'm going to approach those more from the legal vantage point and the statutory vantage point, because I think that's what your committee at its core is interested in. What can you do to possibly modify the statutes that you've passed in order to make sure that they're being implemented the way that you hoped they would be incorporated by the judiciary? So I'd like to make 3 points. The first one is to talk about Justice Sonia Sotomayor's concurring opinion last week that I think really encapsulated the issues that are at stake before this committee and analyzed the record succinctly as to what's going on in this case. The second point I'd like to make is very briefly talk about what you just asked me about, which is how did all this come about? What did things look like before the passage of the statute, and what did they look like after? And I'll do that very briefly. And then the third point I'd like to make is to make 6 possible suggestions for changing the statutes that are involved and that implicate this case. Some of them are, I think, pretty basic, and then some of them may be further than you're willing to go, but I'll just briefly mention those that come to mind. And I think, frankly, there's many more changes that could be made, but I didn't want to be here for 10 hours. I think you all will appreciate my narrowing the suggestions down to about a handful. So with respect to Justice Sonia Sotomayor, on October 17, 2024, the litigants in this case asked the United States Supreme Court to intervene on Robert Robertson's behalf. The United States Supreme Court declined to do that, explaining that it was not a federal issue that was at stake, that really what was involved here was a state statute that should be interpreted by state officials. However, Justice Sonia Sotomayor took the position of writing a concurring opinion to explain how she saw the case and how she felt it should be addressed. She's made 3 points that I'd like to mention here. Her first point was that Robertson, quote, has raised credible evidence of actual innocence, and that there was, quote, mounting evidence that Robertson had, quote, committed no crime at all. This is a United States Supreme Court justice, the very top echelon of the judiciary of this country, and she reviewed this record and the legal issues and the factual issues, and she came to the conclusion that most likely Mr. Robertson is innocent. And I think that's a noteworthy comment of hers that we need to respect and observe. The second thing that she said was that the state relied on the science underlying shaken baby to explain the injuries as a core part of its case. From hearing the testimony today, it appears as though we're now having revisionist history, and that the prosecutors are now trying to claim that this wasn't a shaken baby case at all. And I think many of the speakers today have challenged that conclusion, and rightfully so. And that was, in fact, what Justice Sotomayor also said. She said that, quote, the state's expert had disavowed a beating or impact only theory of death at trial. In other words, at trial, the state did rely heavily on the shaken baby evidence in order to show that the impact that occurred was from the shaking that occurred rather than from a fall from a bed, as Mr. Robertson had explained. I briefly reviewed parts of the trial record by Dr. Squires, who was the shaken baby expert that the state relied on at trial. Squires said, quote, "The actual brain injury we do not feel is explained by a simple impact." She said, quote, "There had to have been something more than just impact." So it's very clear in looking at her trial testimony that the state didn't say that it was because of this impact only that Nikki, the child, died. Rather, at trial, the state made it very clear that this was a shaken baby case, and they used that theory in order to explain why the impact was a grave cause of the result of Nikki's death. So this was not just an impact case as it's now being portrayed. Rather, the evidence of shaken baby biometrics was at the core of the state's theory about Nikki's cause of death. Plain and simple, as Justice Sotomayor noted, this was a shaken baby case. The third comment that Justice Sotomayor made was with respect to the impact evidence. Because it appears as though, again, with revisionist history, the state is trying to contend that this child was beaten or severely damaged by Mr. Robertson. But in fact, after the trial attorneys found CAT scans that were taken directly after Nikki's admission to the emergency room. And those scans showed only minimal subdural bleeding. The reason that's important is because it's clear that that is most consistent with what Robertson said, which was that the child fell. All of the other damage that the jury heard about and that lawyers are now on the prosecution side trying to point to, all of that damage came from the surgical intervention at the hospital to try to save Nikki's life. But that is certainly not attributable to any misconduct by Mr. Robertson. So I respect Justice Sotomayor greatly in her intellect. I think she examined this case, and I think she really crystallized what the issues are and why it's pretty clear that there's strong evidence that Mr. Robertson is actually innocent. The second comment that I would like to make has to do briefly with what the court was like before the passage of Article 11073. I was on the court in 2011 when we first had to decide the Neil Hampton Robbins case. That was another case of a man accused of killing his child. I think that baby's name was Tristan Rivers. The medical examiner in that case said that Tristan had died, I believe, from asphyxia. Many years later, other medical examiners looked at that evidence and gave and said that that was not the cause of death. And then the medical examiner herself re-examined the case. And when she did that, she withdrew her conclusion that it was asphyxia, but she said that she believed the cause of death was undetermined. I thought that that was enough for my court to grant Mr. Robbins a new trial. But my court disagreed, and they upheld that conviction. So to them, it really didn't matter that the medical examiner herself had changed her medical conclusion. It didn't matter that the cause of death was undetermined. The court felt satisfied to uphold that conviction. So after that, the legislature examined the issue of bad science used in courts And it had other instances of bad science, like the Cameron Todd Willingham case and other cases. And that's when the legislature acted to pass Article 11073.
Wait, can I stop? In that first case you just referred to, Judge,
Yes.
you said your opinion while you were in the minority was that the law at the time should have provided relief in that case.
It was complicated because if I remember correctly, the lawyers were trying to rely on a false evidence theory, that the medical examiner had given false evidence at trial. But the problem with science issues is that at the time she gave her testimony, she wasn't lying. She wasn't trying to mislead anybody. That was what she believed the correct science was at the time. So the way I addressed it was just to try to say that we should focus less on whether she intended to lie, but just more on the fact that the testimony was mistaken. But as I recall, my court was, the precedent in the court at the time required more proof of, I guess, a bad intent or something like that. And she didn't have a bad intent. That was just what her training was at that time. And as she got better educated and as she got better trained, then she changed her scientific opinion. And that is why junk science or bad science is so different from, let's say, false evidence cases. The bad science was, in fact, not correct at the time based on information learned later. So there's not any kind of bad faith or bad intent or anything like that by the experts who are giving the testimony. They are relying on their best assessment at the time. It's just that, as we know with science, it develops and people learn more and people get better experience. And when that happens, sometimes they find out that what they said was incorrect before. So it didn't really fall squarely within the false evidence jurisprudence that we had at the time, but I thought that we could make it fit, for lack of a better explanation. So 11073 was passed, and that was a good thing. But even then, the court was discussing whether what happened in the Robbins case fell within the new science statute. And I think at some point we granted relief, and then at some point we granted a rehearing, and then there were lots of different concurring and dissenting opinions, and finally Robbins got the relief that he was due many years later. But I looked back at I dissented every single time in favor of Robbins. Let me rephrase that. I either dissented or agreed each time that Robbins was entitled to relief. But what I wrote in 2016, now looking back, seems to prophesize what's actually happening here today. In talking about how my court had handled Robbins through the various stages of the case, I said, quote, "I do not envy the position of future litigants who must try to decipher this court's position on when relief is warranted under the new science statute." I also said, quote, "This court's judicial decision should not require litigants to run to the legislature for a statutory response to correct our judicial mistakes. This court's judicial decisions should not give the appearance of indecision or manipulation for the achievement of a desired result." Obviously, I was frustrated with how my court seemed indifferent or unwilling to take a common sense approach in addressing bad science and in making sure that litigants got a fair shake at their trials. The third comment that I would like to make has to do with some possible changes that the legislature could make in order to make sure that this doesn't happen again. I think you heard about the Texas Defender Services assessment of how 11073 has been handled by the Court of Criminal Appeals for the last decade. And it's not a good picture of the court.
Judge, 1 second.
Yes, sir.
Chairman Darby has some questions for you.
Yes, sir.
I just wanted to, could you elaborate on that exactly from your perspective on how these cases have been handled now? Could you give us your understanding of what the Court of Appeals is looking to and how they're reaching these decisions now?
Yes, sir. And frankly, that's part of what I was about to talk about, but let me answer your question and then I can probably go into more detail. I think part of the problem is that the court, in all respects, views legislation quite narrowly. And so, for example, in this statute, it talks about, let me quote the language of the statute, that the statute requires that had the scientific evidence been available at trial, on the preponderance of the evidence, the person would not have been convicted. And frankly, there's two parts of that I think are problematic. One is the burden of proof of preponderance of the evidence, and the second one is the language that the person would not have been convicted. I think the Court of Criminal Appeals is looking at both of those terms harsher than it should. Preponderance of the evidence means more likely than not. And so what the defense has to do to obtain relief under junk science is to say that given the new science, or what we now know about science, more likely than not, the person would not have been convicted. Now, I look at this Robertson situation based on what has been presented here at your hearing, and I think many of us look at it, and Dr. Phil looked at it, and John Grisham, and any number of people look at it, and they say, well, of course, by a preponderance of the evidence, what we know now about shaken baby, he would not have been convicted. Even the juror who just testified said, what we know now, he would not have been convicted. But the Court of Criminal Appeals is apparently not looking at that way. They are splicing out the two issues as if they're totally separate things. They're trying to say, well, if you just look at this impact evidence, then the jury could have relied on that in order to convict Mr. Roberson. I think that's not what they should be doing. They're supposed to be looking at the totality of the evidence and listening to somebody like the juror who says, oh, no, that was the whole theory of the case. But I think on the appellate court, they end up doing much like what the Attorney General is doing here, and just picking out pieces of evidence and saying, oh, there was this impact, and therefore the jury could have looked to the impact, and based on that impact, the jury, the defense has not shown that by a preponderance of the evidence, the person would not have been convicted. It gets highly technical, and I think some people lose their common sense some judges lose their common sense when they're looking at something like that.
Question, is that a bar too high? Clearly, I mean, they have to prove their innocence. I mean, before you can even have the court consider a new trial. They have to prove it. And if the evidence was never presented at the trial, how can the court come to the conclusion that by throwing out this junk science, that they would be considered innocent of the charge? Seems like that it's extraordinarily high bar to have to reach for these folks to. I can't see how they would prove their innocence. And clearly, the Court of Appeals and their decisions since 2013 have used that higher standard and not throwing out cases that they probably should have, having considered this high threshold that we didn't set.
I agree. I think they are interpreting preponderance of the evidence too high. I think one thing the legislature could do, because it is such a difficult burden for the defense, would be to, instead of saying by a preponderance of the evidence, you could use probable cause. For example, you could say that had the scientific evidence been available at trial, does the probable cause show that the person would not have been convicted? And probable cause then is a lower standard that would be easier for defendants to meet, given how difficult it is to establish the change in the science and how it affected a trial. That was frankly one of the things I found most difficult when I was on the Court of Criminal Appeals, is that we were having to go back 20 years, and it's almost like looking into a crystal ball. Well, what would the jury have done if they had known then what we know now? And it's all really speculation on the part of judges. It's not like you can go, most of the time you don't even hear from jurors the way y'all just did. Usually the judges are just pretty much speculating in their own how they think an error or a matter or science or whatever affected what the jury did. It's problematic and it's difficult, and it requires common sense and good judgment. But when the judges are inclined to uphold convictions or death sentences, if that is their leaning, then they're going to find ways to side with, let's say, the state, or if their leaning is to side with the defense, they're going to side with the defense. In other words, it's very much within the mind of the judge how they weigh how an error or evidence issue affected the outcome of a trial. It's difficult and it's complicated, and it is somewhat in the mind of the judge.
Well,
in
Judge,
the particular mind of.
another question. You were on the court in 2015, were you not?
Yes, sir.
2015? And so the legislature attempted to change these standards in 2013, which you just referred to, but in 2015, we added some more language to it. And we kind of elaborated, instead of junk science, we said field of scientific knowledge. And then we asked the court to consider a new item, which is whether a testifying expert's scientific knowledge had changed. How did the court view that, and did that help you come to the right conclusion in these cases, or do you still find, were you still find an inadequate standard, if you will, by which the court could evaluate these cases?
I was glad that the legislature did that. If you read some of those Robbins opinions from the first time I think we addressed Robbins when you passed the statute, there were some dissenters who I think felt that the medical examiner's revised opinion was not enough, because like I said, she didn't go back and say, originally she said it was, the cause of death was asphyxia. Then later she said the cause of death was undetermined. And what I think some of the judges said was Well, for her to disavow the science, she should have said the cause of death was not asphyxia. So they wanted the direct refutation of her earlier testimony. But of course, she couldn't do that in her mind, because in her mind, she didn't know what the cause of death was. So she couldn't totally refute cause of death. She could just say, I now believe it's undetermined. So this language of field of scientific knowledge, I think, was somewhat intended to deal more broadly with this situation where the new science didn't have to like entirely refute the former science, but it did have to, but it did allow more permissive use of the junk science statute. In the Robbins case, what was peculiar was that the court granted relief. It was late one year, I can't remember the year, but we had a court of 9 judges. And meanwhile, the new statute was passed. 3 of the judges retired. Then the following year, those 3 judges were replaced by 3 new judges. The state then asked the court, they filed a motion for rehearing, asking us, or a motion for reconsideration, I can't remember how it was phrased, but asking us to revisit the grant of relief under the 11073 statute. So then the new judges came in, and then they voted to grant the rehearing or the reconsideration. And then the case was pending for quite a while. And then ultimately, I think the new judges, most of the new judges decided to simply reinstate the former opinion. But I think Judge Richardson in particular said that in his concurring opinion, I think he said in particular that he did not think that Robbins had been entitled to relief under the original 11073 statute, but that he felt that Robbins was entitled to relief under the amended one that had added the field of scientific knowledge terminology. And beyond that, I'd have to go back and read Judge Richardson's opinion to see why he felt like the former one didn't cover the grant of relief, but that the amended one did. But anyway, to answer your question, I think it was important to at least Judge Richardson that you had amended it, because if you had not amended it, then implicitly he would have voted to deny relief to Robbins. But the court just looks at these statutes in an overly technical way, and that is in fact what many of my complaints are about how the court has handled some of the cases. I don't want to belabor the point too much, but I would like to mention the 6 ideas, I suppose, that I have. These have not been vetted with any of the stakeholders who may be interested in this issue, and they may have better ideas or better phrasing for what I'm talking about, or they may well oppose them. But these are some ways that I think that we could make better inroads into addressing junk science in the courtroom. I think the first thing would be, frankly, to avoid what happened last week. You could change the number of judges required to stay in execution. Last week, there were 4 of the 9 judges who, I think before this body intervened, 4 of them had voted to stay the execution and to give further attention to Robertson's pleadings. So this came down to the vote of a single judge. The decision was 5-4 to allow the execution at the Court of Criminal Appeals level, although 4 of the judges wanted to stay it or to not allow it to move forward. I think where the issue of innocence is involved, or where junk science is involved, this court could easily say that 4 judges would be enough to stay an execution, that you wouldn't need a majority of 5. Another possible option, and this one is a long shot, but I'll mention it only because I have thought it for quite a while, but I won't belabor the point. Texas and Oklahoma are the only 2 states that have 2 state Supreme Courts, a civil Supreme Court and a criminal Supreme Court. Every other state in the United States and the federal government have a single Supreme Court. And the Texas Defender Service has looked at that issue in the past. They say that the Court of Criminal Appeals has a much lower reverse rate in capital punishment cases than these other states that have a single Supreme Court. I believe the criminal specialization has turned the court into a body that really lost its common sense. It's looking for all of these technicalities, and the criminal law has become much more prosecution favorable in Texas than in other states where general jurisdiction judges can compare the jurisprudence to how other litigation is handled. And that obviously would involve deep research. It would involve a constitutional amendment. So I mentioned it somewhat in passing, but I have felt that way for quite some time. And I'm not alone. Many people also feel this way, including at the time he was on the Texas Supreme Court, now Fifth Circuit Judge Don Willett, Justice Don Willett, used to express the need for a single Supreme Court in Texas. I think if we'd had that last week, you wouldn't have had that situation where the state Supreme Court was ruling one way and the Court of Criminal Appeals was ruling another way, and it created a conflict between the courts. I think all of that could be avoided by having a single Supreme Court. My third comment has to do specifically with the statute. What the Texas Defender Service report told us is that there are too few cases that have been filed under Article 11073. Only 74 applications have been filed under the statute in the last decade. Think about that. In all of the thousands and tens of thousands of cases litigated in Texas, really for over a decade, because these look back to several decades back. The statute applies not only to after its passage, but even several decades past. Only 74 applications have been filed, and only 20% of those have been granted. And almost all of the grants are in DNA cases. Only 1 person without an attorney was granted relief, and there have been no junk science grants in capital murder cases. I think that shows pretty clearly that this statute is not being used the way that people had hoped it would be used to bring justice to Texas. So what can you do about that? I've mentioned what I'm about to say in the greater context of post-conviction habeas litigation, but if the legislature wanted to start more narrowly, this would be the perfect place to do it. I believe that if a defendant has made an arguable assertion that junk science was used in his or her case, or if it's one of those issues that we know historically have involved junk science, and I think that list is in the report, so I won't report my TDS, so I won't repeat it. But in these types of cases, the statute could require that counsel be appointed and that funds be granted for experts, defense experts. The problem is that when I raised that, the Texas legislature does have a statute, I don't remember the number, that does permit trial courts to appoint counsel in writs of habeas corpus. The problem again comes back to the Court of Criminal Appeals. The Court of Criminal Appeals refused to enforce the statute. The Court of Criminal Appeals said that it was a wholly discretionary statute, and that if the trial court chose not to appoint counsel, it would not review that denial. So I would require, once there's been some showing, appointed counsel. I'm sorry, yes, sir?
Judge, I just want to dig down into that. So their reading of that particular provision is that that's discretionary at the trial court level, and they're not going to upset that. They're just completely deferential to that.
Correct.
So depending on which district court you're in front of, you either have right to counsel or not in one of the most important legal proceedings you're going to be a part of?
If it's a post-conviction habeas litigation, the court said there is no right to counsel.
I have a question.
Unless there's like an evidentiary hearing.
Sure,
unless
sure.
there's
No, I
some
get
rare-
it. Sorry, I just wanted to drill down on that point real quick. Representative Leach, or Chairman Leach, sorry.
Sure, Judge. Good afternoon. Thank you for joining us. It's good to see you
Oh,
and
thank you.
work with you. Can I just follow up on that? Help my understanding here. Is there a federal action for grossly negligent assistance of counsel in violation of the Sixth Amendment? Is there any sort of federal relief at that point, or no?
There can be. That's gotten pretty complicated where a lot of times the federal courts will look to have the state court handle something. And so it can get pretty complicated about when somebody can get federal relief and when, or even appointed counsel and when they can't.
Justice
but
Sotomayor
it is possible.
mentioned in her opinion last week. I don't have it in front of me right now, but she basically said that we don't have an actionable federal claim for the Supreme Court to rule on. In other words, there was no case for them to rule on. They kicked it back down to the states. How do we get? Do you have any sort of opinion on how we get a federal claim in a case like this?
Well, you're not going to get it under 11073 because
Right.
that's clearly a state statute. A lot of times they'll frame something like this, like you pointed out before with one of the other speakers, that this could potentially have been raised as ineffective assistance of counsel, at least in theory. But again, you have to step back to what the environment was, I don't remember if it's 20 or 30 years ago. You have to step back in time and realize that back then, shaken baby was considered a plausible theory. And in all candor, when I was a prosecutor, I prosecuted a shaken baby case, which I now obviously thoroughly regret. But that was how prosecutors were taught. That's how, that's what doctors believed, and that's what the doctors said. And so that's the problem, is that how do you blame a defense attorney for, let's say, conceding like he did at trial, oh, this is a shaken baby case, because, and I don't know if this lawyer was a great lawyer or a terrible lawyer. I haven't dug into the record enough, and I don't want to commit one way or the other. My point is simply that I can understand why a defense lawyer 20, 30 years ago, knowing that that was what the experts were pretty universally saying. I even wonder, could he not even find an expert to say something different back then? That part I don't know. Did the trial judge give him or her funds to hire an expert to try to find somebody to say something different? Those are all unanswered questions for me. But regardless, I can see how this lawyer at the time would have conceded shaken baby, because that's what the science was at the time. And that's why this statute is so critically important, is because this statute doesn't really assess bad faith on the part of the experts. All it says is that things have changed, and today we understand this science differently. And so that's the problem when you try to intertwine something like ineffective assistance of counsel. You have to meet that burden that at the time he or she behaved unreasonably, and I'm not sure you could prove that in this case. I mean, it's possible perhaps if I looked at it, but my suspicion is that that's why maybe ineffective assistance of counsel may not have been something that they could win at the federal level. So for the federal courts to get involved, you've got to have a federal constitutional issue. And so what I'm suspecting is that these very skilled lawyers that we have here today have been unable to find a federal constitutional issue at play.
Okay, thank you, Judge.
Well, either, I'm sorry, let me correct that. Maybe they can't find it, or maybe the time, maybe that was litigated in the past and they don't have grounds to relitigate it today.
right.
I can't speak to that.
Representative Harrison, you had a follow-up question?
Yeah, just very quickly. Thank you, Judge. You mentioned a second ago that you personally had prosecuted some shaken baby syndrome cases. Did I hear that right?
I did one. One comes to mind.
One, roughly, do you remember, if you remember, what year was that?
I don't, but I was a prosecutor from 1989, and I left December 31st of 1998, and I think I tried it when I was a chief prosecutor, so that would have been in the last 5 years, so it would have been between, let's say, probably 1990, sometime between 1993 and 1998.
Okay, no, so mid-late 90s. Where I'd like to hear from you, are you aware that, and again, as this is my understanding, so feel free to correct me if you understand it differently. My understanding, even amongst the elements of the medical and scientific community that are still adherents to, shaken baby syndrome or AHT, and say that it still can have some applicability in criminal cases, and my understanding is that now, in 2024, it's sort of a diagnosis or a theory almost of last resort. Like once all the other plausible alternatives or explanations have been considered and excluded, then you could consider this as something that might be an hypothesis that matches the data. When you were prosecuting a case like this in the late 90s, was it your understanding that when the classic triad was present, that would be sufficient to determine this was shaken baby syndrome, and that abuse could therefore then be presumed? Are my facts right, or am I wrong?
I think that's right. I mean, I don't remember a whole lot about the case that I tried.
Okay.
But it was, I want to say, a babysitter, and she claimed she had not hurt the child. And I did not believe her because the doctors involved in the case told me that exactly what you just said. They saw these signs in the medical evidence, and because of those signs that they saw, their expert conclusion was that it was either shaken baby, I don't recall, or shaken baby impact, one or the other. But those are intertwined. That's what's kind of a fallacy that's being portrayed by I think the prosecutors in this case, is they're trying to make it seem as though, oh, these are just totally separate things. The way that the impact is determined to be not from a fall, for example, is because they say that because of that triad, they can conclude that the impact was of the force of like a car. I remember them always saying, oh no, you have to shake so hard that it's like as if somebody had been hit by a car. It was that kind of testimony by the experts. And so as a prosecutor, I didn't question my experts. They were my experts. They were qualified and trained and educated
but just real on I think the heart of the question I'm trying to get at is where the triad was present, and granted, you of course were relying on medical experts, where the triad was present in the 90s, back in that era, abuse, it was sort of like commonplace for abuse to therefore then be presumed to have occurred.
I believe it was universally.
That tracks with your recollection.
I think, if I'm understanding the question, I believe, yes, I believe that's what the experts were saying, and I believe that's what we prosecutors relied on to pursue these convictions.
Thank you, Judge.
All right, and I think you were going through your list of recommendations, so if you want to pick up back where you were.
Sure. I think I was talking about the Oh, the appointment of counsel. So I would not only require the appointment of counsel and funds for experts, but I would also make it clear that they're entitled to appellate review if the trial judge decides to either deny counsel or deny funding for experts. I think that you can't just leave that up to the whim or judgment of a trial judge. I think that that should be scrutinized by the appellate courts. My fourth thought about possible statutory changes would be something I think that I briefly mentioned, which has to do with the burden of proof. Right now, the burden of proof is preponderance of the evidence. I think you could consider lowering that to probable cause, simply because it is so difficult to prove these cases, as we've seen in this case, that sometimes it doesn't fall squarely within some of the language. And I think lowering the burden may make it easier to address bad science that is used in courtrooms. And I think you could say that the new science probably would have changed the outcome of a trial, and that should be enough to at least warrant a new trial. Like Mr. Grisham said, it's not as though granting this 1107-303 relief is a declaration of innocence. All that the 1107-3 relief does is prove an entitlement to a retrial. Innocence would be handled under a different post-conviction habeas statute. My fifth comment has to do with today the statute says whether the defendant proved that he would not have been convicted with the new science. And we've talked a little bit about that as well, how difficult it is to go back in time and to kind of assess whether that new science would have led to an acquittal or not. And that's a pretty difficult thing to do. So I was thinking that perhaps you could add language to the statute that would say the following. Right now it says the court makes under B, the court makes the findings described by subsections 1A and B, and also finds that had the scientific evidence been available at trial, on the preponderance of the evidence, the person would not have been convicted. That's what it says now. It could possibly say, or the state's or defense's core theory about a defendant's guilt or innocence would have been materially altered. I think that's part of what we're seeing in this case is everybody can see this and say this was tried as a shaken baby case. The defense lawyer acknowledged this is a shaken baby case. That was the core theory at trial. And because we know that this case was litigated under that theory, it seems to make common sense that now that we know that that was not a proper theory of conviction, that or a proper theory of guilt, that that there should be a new trial granted. So perhaps if that language was altered to focus more on the theory of litigation that led to the conviction as compared to requiring absolute proof by a preponderance of the evidence, that there would have been a different result. I think it's that suggestion that you're looking at whether the result would have been different, that's what's causing the problems in this case, at least as I am assessing what's going on. The sixth issue, which is my last suggestion, but I have several thoughts about it, has to do with the procedural bars. The Texas Defender Service report from this summer said that 28, about a third of the or maybe of the 74 applications were denied or dismissed on the basis of procedural barriers. problem with that is that when a procedural barrier is applied to a case, the court never gets to the substance at all. All it says is, because of this procedural reason, we're not going to even talk about the substance of the statute and whether it warrants relief in a case. And that, I think, is problematic across the board for habeas relief, but it is particularly problematic in terms of junk science. So I think there's some real simple fixes to this. I think the legislature could expressly allow the state to agree to waive any procedural barrier in the interest of justice in any habeas case, but in particular in junk science cases if you wanted to be more narrow. Right now, the Court of Criminal Appeals does not allow those waivers, or at least last time I read, that may have been an issue that was before the court. Frankly, I'm not sure that they ultimately decided that, but that would be a statutory fix to allow waivers of procedural barriers in the interest of justice, because right now there's many elected district attorneys who truly are interested in justice, and they should be able to waive any procedural reason that would cause the court to not grant relief. That may be a little confusing because I'm going to pull back from junk science for a second to talk about what these procedural barriers are. In habeas litigation, the court will look at whether the issue had been litigated before and say, well, it was litigated before, so we're not going to let you litigate it again. In general, that's fine. Where the court, in my opinion, went astray is that it's gone far beyond that, because it not only says, was it litigated before, but the court says, could it have been litigated before? And that's when it can get pretty difficult, because if the prior lawyer was ineffective, he or she didn't bother to look. But if the defendant had an effective lawyer and bothered to look, then yes, in theory, it could have been litigated before. But regardless, it wasn't litigated before. So the court is not really focusing on what did happen. The court focuses on what could have happened if the defendant had valid counsel or good counsel.
Well, and also, Judge, to that point, because I think this is, it also matters, in that analysis of could it have been litigated, the time differential between the decision and the question we're talking about, like the perspective matters, right? I mean, I think it goes to this case. If you tried this issue today, there are, that you're going to have an enormous amount of evidence that comes forward talking about shaken baby syndrome and how it is a debunked form of science and all that stuff. So the lens by which the jury would view it is significantly different. In fact, the lens by which any defense attorney is going to evaluate it is significantly different. Going back in the day, I could say, yes, there were people back then in 0203 timeframe that could have raised some questions, some concerns. Maybe they could have come up with a novel argument at the time, but it wasn't a prevailing objection to this type of evidence at that time. So even if you say, yes, it could have been raised, well, sure, but the context matters, right? And so I've had trouble trying to get my arms around that, because we're looking backwards and we're putting these constraints on the concept of what could or couldn't have happened, and we've got to get out of that framework. We're trying to talk about whether there's fundamental fairness to this individual, and getting into could it have been litigated before opens up a myriad of problems.
So I would either remove all procedural barriers to all or many of the procedural barriers to the application of this statute, would be my first choice. My second choice would be, or alternatively, I would say that certainly the elected district attorney should be permitted to waive any procedural barriers in the interest of justice. in order to ensure that the right people are punished and the wrong people are not punished. And one of the recommendations in the Texas Defender Services report this summer was that the legislature could require that when the Court of Criminal Appeals dismisses or denies relief under Article 1107, that the court should be required to detail its reasons for dismissing or denying relief on procedural grounds. And at first, I wasn't convinced by that suggestion, but the more that I have thought about it, the more I think it is a valid idea, because of the fact that you legislators are in the position of trying to figure out how to make this statute work better. But the problem is the Court of Criminal Appeals is not explaining itself as to why it's ruling the way that it's ruling. And so you're trying to have to guess, well, what procedural barriers did it apply? And why did it apply those procedural barriers? And why isn't it intervening in these cases? But if you require a detailed explanation, then maybe you will find out how the court is deciding these cases. And then if you do want to be more proactive in this legislation, you could then write or amend your statute in order to make sure that you statutorily incorporate the parts of their analysis that you agree with and the parts that you disagree with. But I do think that additional information may be helpful in drafting the statute in such a way that you are avoiding situations like this one where it's unclear what the court is thinking in reaching the decisions that it's made. So I think I'll stop there. I've given you a lot of, very technical information, and it is complicated, and from, most people's eyes will glass over when you get into these technicalities, but this is why the system isn't working. It's because I think the court has not used a common sense approach in applying these statutes, and it's been over technical and too and it leans too far to uphold convictions and sentences that I think many other Supreme Courts in other states would reverse.
Judge, thank you. Let me make sure I have only one last question for you. Is anybody else? Chairman Leach.
Yeah, thank you, Judge. Just one more area I wanted to cover with you, with maybe just one, possibly two questions. As judges, as we look forward, as we assess where we are on the Robert Roberson case now, and we look forward as to what options could be available. You having spent time as in the district attorney's office, I believe at one point you were chief felony prosecutor in Harris County, and then as a district court judge in Harris County, and then of course on the Court of Criminal Appeals. So you have a unique perspective, having been in the seat of the decision makers that are currently at play here in Roberson's case, the district attorney's office, the district court, and the Court of Criminal Appeals. What are the options going forward for someone in Mr. Roberson's case? Well, let me just ask you, what in your mind are Mr. Roberson's options going forward at this point? Of course, the wish, the hope of this committee would be a new trial could be achieved, and all of this could be retried. But is that possible? Short of a how do we get there?
That's a good question. This is what I believe should happen. So because of the good work of the Texas legislature, now defendants are entitled to 90 days notice before an execution date is set. We know that the last execution warrant expired. The execution didn't take place that day, so that warrant is no longer valid. So now, assuming Palestine wants to continue to move forward with execution after everything we know here, they could schedule an execution date 90 days from now, which takes us into 2025. But as we know, there's an election that's about to take place. 3 of the judges who voted against Roberson last week, in other words, they voted to permit the execution to move forward last week. 3 of those 5 judges lost their primary elections in the Republican primary. Those are Judges Slaughter, Hervey, and Keller. So they will not be there anymore in January 2025. There'll be 3 new judges, whether they are Republicans or Democrats. Regardless, there's going to be a third of the court that is different starting in January 2025. So 4 of the judges who voted for Roberson will still be on the court in January of 2025. That was, I think, Judge McClure, Newell, Richardson, and Newell. They will be there January 2025. You have 3 new judges, whether they're Republican or Democrat, as well. And then you only have 2 judges still on the court that ruled against Roberson. That's Judge Yeary and Judge Keel. In theory, even if one of the new judges, again, regardless whether it's a Democrat or Republican, even if one of those new judges joins the 4, then hopefully there'll be a majority of 5 to formally stay the execution by the Court of Criminal Appeals, and hopefully they will grant rehearing of the 11073 issue. They can do that on their own motion. They don't even need a motion by Roberson's attorney. I'm sure she will do that, but they don't even need that. They could, on their own, sua sponte, take what's been filed, add the vote of the 5th new judge, stay the execution, and then they can take as long as they want to dig into the issues that have been presented before this committee. That is what I hope happens. That's, I think, best case situation. Worst case situation is that whoever the 3 new judges are that are elected, end up siding with the 2 judges who voted against Roberson. Then we're back in that situation where there's a majority vote to permit the execution. And if that happens, I frankly don't know of a way to avoid execution. I hope I'm wrong. I hope his lawyers have ideas that of which I'm unaware, but it could still happen. I can't imagine that happening, but I also couldn't imagine last week at 8 p.m. When he was still eligible for execution. I couldn't imagine that was the situation taking place. I would never have foreseen that situation, and I do believe it would have been a tragedy if that execution had taken place. It is a credit to this organization that you saw this injustice and that you did what you needed to do to try to make sure that innocent people are not executed in Texas, and that people have valid and credible findings of guilt. And I don't know if you're getting any criticism, but I don't think you should. I think we should always err on the side of justice because, you know, at most, if the execution still takes place, it was just a delay of a few months. And if it doesn't take place, then you have saved the life of an innocent person. So I just don't understand.
Sure. Judge, let me,
unwillingness to grant a stay.
let me just follow up on one thing you mentioned there. You mentioned that the court could, on its own volition, sua sponte, move forward with a stay of execution. Does there have to be, and just excuse my ignorance on this, I don't practice in this area, so there are, in my own mind at least, no stupid questions here. And can the court now, without a pending, without an execution warrant being active now, can the court sua sponte now, if they so wanted to, if one of those judges who didn't vote the way that I think most of us would have liked for them to, or expected or hoped for them to, and I have great respect for and know many of those, if not all of those judges, and I disagree with them on this strongly, but I still have great respect for them. If one of them had a change of mind or a change of heart, could the court now sua sponte do anything?
Yes, and I agree with you. I have a lot of respect for my former colleagues, and I reiterate it's an extremely difficult job that really can be difficult for the people who've undertaken the role. And I think I misspoke. So there's two possible things that could happen. One is the application for habeas relief under 11073. The second thing is a motion for a stay of execution. So on their own motion right now, the court could sua sponte decide to reopen its 11073 habeas decision. We used to do that sometimes at the urging of defense counsel, and sometimes one of us internally would say, we need to relook at this issue.
Wait, Judge, I want to stop you there because I think that's that may be new information for legislators or people who are tuning in. So if one of the current judges between now and January, if later today or tomorrow or next week had a change of heart or a change of mind, which I think we're all going to still continue to hope and pray for, they could actually act now sua sponte and claw this back into the district court?
My position is yes. I mean, we did reopen habeas applications that we had decided. We did do that. And sometimes the lawyers would file like a suggestion for reconsideration is how they would style it, because it's not a rehearing in the technical sense, but they would style it as a suggestion for reconsideration. And I think the defense attorneys in this case may have framed it that way, but I'd have to go back and look at it. But yes, on their own motion, they could say, we internally have decided to reopen and reconsider this 11073 ruling, and I believe they could today decide to reopen it and decide to order further evidentiary hearings. Typically what they would do is they would remand the case back to the trial court for more factual hearings, and then the trial court would make findings of fact and conclusions of law. The lawyers would have litigation down there. Then the case would come back up to the Court of Criminal Appeals, and then the lawyers would file their briefs and arguments, either saying that the trial court got it right or in its findings of fact and conclusions of law, or the trial court got it wrong. But that's typically how this habeas litigation works. The motion to stay execution is different because there's no execution pending. So they wouldn't change their ruling on that because there's no execution that's been set. You know, a third option is that the DA in Palestine could just decide not to set an execution date until further time. Maybe that DA would want to go back and listen to all the testimony. Maybe they would, hire an expert to come in, a prosecution expert to come in and review everything in the case in order to give them an impartial assessment. I mean, there's any number of things that the DA's office could do in order to not seek another execution date.
You know,
But,
and
I believe we could do something together.
just as one last closing comment here, I'll just thank you for your testimony and for answering my questions. I just, in the legislature, I'll just speak for me. I know there's been regular occasions where even on some major legislation on the floor of the Texas House, public for everyone to see, where I've voted a certain way and realized either right after I did or even later after the fact that I got that vote wrong. And we, under our House rules, have the ability to get up and to walk to the journal clerk and to, again, in front of everyone, kind of joke about it being the walk of shame, go up there and we change our vote. And we can add statements into the journal. And there's been multiple occurrences where I've, gotten it wrong. And it sounds to me like there is a tool in the toolbox for our current court to do the same thing. Or not even to say that they got it wrong, Judge, but just to say that they might have gotten it wrong. Right? So one judge saying, I think I got it right, but I'm willing to admit that I might have gotten it wrong. That's all it would take. Correct?
Yes, and frankly, the four of them who voted for a stay really have not committed that they're going to rule in Robertson's favor at all.
Correct.
All they said was what you just said, that they were willing to pause in order to look further. So the mere fact that there's a stay or a reconsideration, all that does is just pause it to make sure that the issue is litigated. It doesn't guarantee an outcome one way or the other.
Which, from my perspective, Judge, is all I've ever wanted. All I've ever been asking for and working towards in this case, I've said it using your words, is the pause button. The pause button. That's it. And I know that that's what I'm going to be praying for and hoping for. Thank you, Judge.
Thank you.
Judge, thank you. I just want to go down a quick path with you before we excuse you, and it's always weird to say we're excusing the judge, but you've been a prosecutor, right? You've served you served on the district bench, presided over cases, and you've presided over the highest level of appeals in this state. All true?
All true.
Okay, so you've kind of seen how things go, and that's kind of what I want to drill down on. Because you've seen criminal cases and trends across the state in your time, in your experience. Is it fair to say that in some places, the prosecution essentially gets everything that they want?
Yes.
Okay. And in some places, juries go along with the state because there's great trust that if someone was charged, then they must be guilty. There's some deference that they give to the prosecutor.
Yes.
And then when it comes to appeals, is it fair to say that there's another layer of extreme deference built into our system that creates an injustice at times?
Yes.
So when things are at that trial court level and how we look at it through the lens of the appellate court level, right? The trial court makes rulings on evidence, and even if they're wrong, they get a lot, that district judge gets a ton of leeway in what we call the abuse of discretion standard. Isn't that correct?
Right.
Okay, so basically what that standard means is even if wrong, it's only did the judge act without any legal basis at all.
Right.
Right, and so that's the abuse of discretion standard. And then we have another deferential standard that we talk about, harmless error, right? That's another deferential standard.
Yes.
And so that means if you're totally wrong, no legal basis, but there's no concrete harm that's proven. So so that's what harmless error means in that context, right? So then from there, your appeals court, they defer to the jury about all the facts, and they assume that because there was a conviction, if there was any testimony at all, no matter how incredible, the appeals court defers to the jury wholly and completely. So now we must do that as well, right? That's the way the appeals court looks at the jury fact-finding.
Yes.
Okay. And in going specifically to Article 11.073, there's a similar process in habeas proceedings. So the habeas court makes findings of fact, and those are the basis for everything that the Court of Criminal Appeals does. Isn't that correct?
In general, the court does not have to, the court can decide that the findings of fact are not supported by the record.
The record, right.
So,
Yep. But the habeas court they essentially do the legwork, build the record, and produce findings of fact and send that up. And that's what the Court of Criminal Appeals engages with in making their decision, right?
yes, but sometimes the court says that on its own motion or on its own review, it's going to do whatever it does. So sometimes it follows the findings of fact. Sometimes it expressly says that the finding of fact is not supported by the evidence. And sometimes the court says on its own review, it's going to do.
They do their own. They do their own, right. And so going back to some of the deference we get at that trial court level, that nuclear part of the trial, which in this case, when you look at that from the 11.073 perspective, the habeas court is that trial court that's taking that evidence. We heard last week in the committee, we actually saw a demonstrative of the findings of fact and conclusions of law that were submitted by the defense and the prosecutor. And I know that that's not determinative of anything, just because you have a stack of paper doesn't mean it. But other than two minor issues, the trial court adopted the state's findings of facts and conclusions of law wholly, completely, except for two minor points. And then the Court of Criminal Appeals, and I think I heard this correctly last week in testimony, wholly adopted those findings of fact and conclusions of law. And I'm not asking you to get into the minds of your former colleagues, but does that sound like a process where the new evidence was meaningfully engaged with that was gathered at the habeas court?
From the way you describe it, it does not.
Okay. Well, I certainly appreciate, Judge, you always have had an open door to talking about some of these most complicated issues, and I want to thank you for your time, not just today, but in service to the state of Texas throughout your career. Certainly grateful for your expertise, because this is really, I think, going back to Chairman Darby's point at the beginning of the hearing, this is the crux of it. What are we going to do? And you've given us some very concrete solutions and thoughts and ideas that we can move forward from here. Because while this is crystallized in Robert's case right here today, there's another Robert Roberson out there somewhere, and we need to start figuring this out. So, Judge, I don't think do we have any other questions before I excuse Judge Alcala? No? Judge, thank you so much. I certainly appreciate all the time you spent with us today.
Thank you, Chairman.
Chair calls Donald Salzman.
Good afternoon.
Hi, good afternoon. Just want to make sure that I have this correct. I have you registered as Donald Saltzman, here testifying on behalf of yourself, and you're testifying neutral on the topic that we have posted for today. Is that correct?
That is correct.
Okay, awesome. I'm going to open the floor to you to provide your testimony. As you've seen, I've seen you sitting here all day. The members may have witnesses, or may have questions as you go. They may jump in, or they may wait till you conclude, but we'll have questions as we go along. So thank you so much.
Thank you, Chairman Moody and members of the committee. I very much appreciate the invitation to talk with you today and your attention and focus on 11073 and Mr. Roberson's case. I do need to make clear that my testimony today is on my own behalf, not on behalf of my firm, and the views that I express are my own.
That's what the record reflects up here. Yep.
So I just want to tell you briefly how I got involved in this case. I'm the pro bono counsel at Skadden, Arp, Slate, Marr, and Flom. I've been in that position, full-time pro bono counsel, for 22 years. But before that, I was a public defender in Maryland, in a suburb of Washington, D.C., for about 15 years. And in 1997, actually while I was on parental leave with my older daughter, I was called by my boss and asked to take on a what was called a shaken baby case. It was a homicide case when I would return from parental leave very soon after that. I have worked on a total of 6 of these abusive head trauma, shaken baby theory cases over my career. And I'm a lawyer who has seen the arc, the evolution in the scientific understanding that was the basis for shaken baby syndrome, move from a period, as you all have heard, where there was a presumption that if the triad existed, then if a baby died, that was abuse and murder, to a position now where the presumption is exactly the opposite. The diagnosis of a plausible other explanation, medical explanation, accident, something like that, has to be considered and excluded before any consideration or the possibility of abuse would be considered. And in those cases, I've seen how hard it is to find expert witnesses, particularly back when I started doing this in 1997, to testify to anything different. The medical community had almost total consensus. So I have a fair amount of experience with these types of cases. I'm happy to talk about at least one of my cases, Clarence Jones, who was exonerated in Maryland when a writ of actual innocence was granted to him in 2021. And I will briefly later talk about some of the parallels between Mr. Roberson's case and Mr. Jones's case. But I got involved in Robert Roberson's case when Gretchen Swen reached out to me. She had heard about my experience, and she asked me whether my law firm would be willing to take a look at Mr. Roberson's case. These are, as you've heard over the testimony last week and today, these are complex, really difficult cases. And I want to take a moment just to say, I've gotten to know Gretchen Swen over the last 2 years. I think I can speak for my colleagues at my law firm and the Innocence Project to say that what she has done to keep Robert Roberson alive over the last 8 years, with help from others, but is remarkable. She's fierce, she's dedicated, and I'm proud to be associated with her. So she asked me if my law firm would take a look at Mr. Roberson's case, and we took a very, very careful look. And what we found are a lot of the things that you've heard over the last 2 days of hearings. I won't go into them in detail right now, but obviously the medical records and trial transcript and expert opinions that were offered at the trial were infused, as you've heard, with shaken baby syndrome theory under several different names, and the terminology, the terms of art that are associated with shaken baby syndrome, abusive head trauma theory was infused in this trial. We looked at this case and we saw that Nikki Curtis was a very, very sick child. And we've now learned that she had pneumonia, which explains her death. When we looked at the case, we found that evidence that she had pneumonia was definitive, but it was not understood or really even discussed at trial. I've already talked about what the medical consensus was at the time that Robert Roberson was prosecuted. And I think the committee has heard testimony from a number of people, as some committee members have said, that the district attorney's office, the attorney general's office, people who are in the community advocating for Mr. Roberson's guilt, many, many people, there has been a retreat from the shaken baby syndrome hypothesis that was absolutely the theory of prosecution at trial. And you've also heard discussion today from Dr. Phil and maybe other witnesses about the unconscious or sometimes conscious, but unconscious bias that infuses these cases. And I think it's important to remember, as many of the committee members have expressed today, and some of the witnesses, and particularly Ms. Compton, that we have to look at these cases from the point of view of what the jury heard, not what the district attorney says they told the jury, not what the medical examiner says they told the jury, but what the jury heard. And when you read the transcript in this case, I think it's very clear what the jury heard: outdated, unverified, unreliable science that was presented to the jury as fact. And it was essentially, as this committee has expressed, a diagnosis of murder. So I was asked to get involved, and we put together a team at my firm. We looked at this case very carefully, and we concluded that there was an injustice. And I told Gretchen that I wanted to see if the Innocence Project would get involved, because I had worked with the Innocence Project, the National Innocence Project, on a number of cases throughout my career, innocence cases. And so I reached out to my contacts at the National Innocence Project and asked them to take a look at Robert's case. And I think it's important for the committee to know that the Innocence Project does not get involved in every case that they're asked. They get thousands and thousands of requests. My firm helped them with a backlog of 4,000 requests for assistance because there's so many people reaching out to them. But they do an exhaustive screening of their cases. They do not take a case where it looks like there might have been poor lawyering just because there was poor lawyering. They don't take on a case because there might have been constitutional errors in the case just because there were constitutional errors, although in many of their cases they find them. They take on the cases when after doing an exhaustive review, they believe there is compelling evidence that the person who was charged and convicted is innocent. So they did an exhaustive review of Robert Roberson's case. And they joined the effort because I think I can speak for them. They believe that there's been a terrible injustice and that Robert Roberson has been convicted and sentenced to death for something that was not a crime. And in many of the Innocence Project cases, the cases they get involved in, as you've heard, flawed, invalid, unscientific science and medicine has played an enormous role in the cases that they've worked on, that they've been able to prove have been wrongful convictions of innocent people. One other thing that I think it's important for you to know about the way the Innocence Project works is that they try to work in a collaborative way. They reach out to prosecutors, attorney generals, district attorneys. They ask to meet with them, to discuss the evidence, to explain why they think there might have been an injustice or why there was an injustice. And they often are taken up on that. But in this case, it's frustrating and unfortunate that that has not been the case. The Innocence Project reached out to DA Allison Mitchell early on when they got involved in the case and asked to meet with her. She was polite, but she did not willingly and she didn't openly discuss the case. I had a chance to be in Palestine, Texas in April of this year. We were reviewing their records to make sure that we had everything that they had. And that was when I learned that they were planning to set Robert Roberson's execution date. And I asked Allison Mitchell if she would meet with us to talk about the new evidence that we had discovered and developed. And she said that she was not willing to do that. The Innocence Project also sought to meet with the medical examiner in this office to share the new evidence that we have developed since the last hearing in 2021. After a lot of process, the Innocence Project was told that the medical examiner would meet with them, but not with any of our experts for 10 or 15 minutes. In a case of this severity, that was a disappointing response. I know it's late. I do want to talk about one of the most significant issues that I think the members of this committee has been discussing, and I don't know, maybe it's the elephant in the room. It is the position of the district attorney, the office of the attorney general, and I think this has also seeped into the one opinion we have from a concurring judge in this case, and that's the allegation, which I'm going to explain why this is really misinformation, that Nikki, upon her arrival at the emergency room in Palestine, had multiple bruises and injuries. The Attorney General just over the weekend filed a brief that said Robert Roberson brought his 2-year-old daughter Nikki to the hospital. Upon arrival, Nikki had extensive bruising to her chin, face, ears, shoulder, and mouth, and the back of her skull was mushy. That is absolutely not true, and I'm going to tell you in a minute why the trial record shows that that is not true. There's also been allegations, as you've heard and you've discussed, about multiple impacts to Nikki Curtis's head. That is the theory now that the district attorney and the Office of the Attorney General is presenting, that this was not a shaken baby case. And as you have discussed, the CT scan, which I'll talk briefly about, but you already know, absolutely refutes that. So let me just talk about a key witness in this case, the first nurse who encountered Nikki Curtis. Her name was Kelly Gerganis. Her name is Kelly Gerganis. And she was in the ER when Robert Roberson arrived at the hospital, handed his daughter Nikki to Robert's then girlfriend Teddy Cox, who happened to be in the hospital for a medical procedure, was in a wheelchair, and met Robert outside the hospital. When Teddy Cox was brought into the hospital in a wheelchair, she said her lips are blue, or she's not breathing, or something like that. And Kelly Gerganis testified that she immediately she saw this bundle in Teddy Cox's arms, and she grabbed the child. Those were her words, and she used that term several times. And obviously that's the appropriate thing to do, but we know because of the testimony last week from Francis Green and Dr. Auer that Nikki had a bleeding disorder, disseminated intravascular coagulation, that causes, even from minor medical touching and procedures, bleeding. So Kelly Gerganis grabbed Nikki, and she testified that when she brought Nikki into the examination room, she said, "I witnessed bruising. There was what appeared to be a bruise right across here," and she was pointing, and I'll get to where she was pointing in a minute, "and down here on her medially." Medially means along the center. And later, she testified that what she was talking about was Nikki's lip and her chin. Of course, that is absolutely consistent with what Robert told the medical staff, nurses and doctors, that Nikki had fallen out of bed, and he told one of the nurses that he believed she might have hit her head or face or something on a table because she was bleeding when he picked her up. Multiple times during her testimony, Nurse Gerganis was asked to describe any other injuries, bruises, or swelling on Nikki, but those bruises that she described were the only ones she described on Nikki. She was asked to describe what she observed on Nikki's head after Nikki was intubated and the police arrived. They shaved Nikki's head, and she testified, as I remember once the police got there, they shaved the back of her head. So they shaved the back of her head, and I don't recall it being bruised, but it was red and it was just mushy, like a soft spot. Now, we know that Nikki Curtis had this bleeding disorder. We know that she was intubated. We know that doctors put a tube down her throat, and the procedure involves, holding the child's face and head still while the breathing tube is placed down the throat. We understand from Dr. Squires, who testified that when she saw Nikki at Dallas Children's Hospital, Nikki's face was taped, and there were other medical devices over her face, so Dr. Squires couldn't see all of Nikki's face. In the context, in the setting of disseminated intravascular coagulation, any bruises that were seen at autopsy that are different from what Nurse Gerganis described, no one can rely on that to say that those were the product of anything other than the medical treatment that she received. Nurse Gerganis also testified that she saw other bruises developing during the time that she saw Nikki in the hospital, which is consistent, again, with the testimony of Dr. Green and Dr. Auer that Nikki had a bleeding disorder. This is what Kelly Gerganis was asked. So those bruises became more apparent as she was being treated. And the answer was, as the time went on, more bruises were apparent. She was later asked, and you were triggered by the bruising that had started to develop? Yes, sir. The testimony from the nurse who saw Nikki first described bruises developing over time. And the arguments that have been made now to defend this conviction are contrary to what the record shows. And as I said, another nurse testified that Robert Roberson told her that he believed Nikki had fallen and hit her head or face on a table and found blood in her mouth, cleaned that blood with a washcloth, which he then showed to Brian Wharton when he was brought to his house. So the bruise on Nikki's lip, the torn frenulum, any other bruise on her face are consistent with what Robert Roberson told people at the hospital. I do want to address a different topic briefly because, sure, of course, yeah.
Thank you, Mr. Salzman. Let me just ask you a couple questions, kind of where you are in the timeline here. Was Nikki, let me just ask, was Nikki alive when she was brought to the hospital?
The medical records show that her pupils were fixed and dilated. That is a grave condition. She wasn't breathing. Her lips were blue. Her brain was essentially, according to the experts, her brain was essentially dead at that point. But she was revived because of heroic efforts in the emergency room.
So when Mr. Robertson brought her in, she was still breathing, correct?
She was blue.
Okay.
The medical records are really not clear whether she was breathing or not.
Okay.
I don't know if you've looked at them. They are really hard to read.
They are. So let's just say we don't know, but she was intubated, right?
She was.
And she was placed on life support, correct?
She was.
And then she was transported to Dallas Children's?
A few hours later.
A few hours later.
Mm-hmm.
And so what date would that have been?
January 31st. And we don't have any records. There are no records when Ms. Swen got involved in this case in 2016. Any records of the transport and what procedures were performed during the transport are no longer available.
No records at all.
Absolutely none.
Why do you believe, or does the record reflect why they transported her from Palestine to Dallas?
Yeah. Nikki was in critical condition, grave condition. Palestine is a regional hospital. It's not a
Correct.
primary, a trauma center.
So, and this is a vitally important point, at least for me, and so I just want to stop here and make sure that we're all paying attention. Nikki was, you just said, in critical condition.
Absolutely.
So there were signs, although maybe a long shot and not, sustainable life wasn't going to be a possibility, but there were signs of life. She was not pronounced medically.
She was not pronounced until February 1st.
Okay. So January 31st, she was transported, intubated, put on life support, transported from Palestine Regional to Dallas Children's.
Correct.
And what was her time of death on the 1st?
Ms. Swen's going to know that better than I. It was later in the afternoon or evening.
So there was a decision made to remove life support.
Yes,
correct?
There was.
Was Mr. Roberson consulted about that decision?
He was not.
At that time, on February 1st, did Mr. Roberson maintain conservatorship over Nikki?
Mr. Roberson had been awarded custody by a court and had been involved in Nikki's care for a few months.
As of February 1st, when the decision was made to remove her from life support, no parental rights, none of Mr. Roberson's rights had been terminated.
That's my understanding.
Someone made the decision, and correct me if I'm wrong when I say this, but somebody, not Mr. Roberson, made the decision to remove Nikki's life support without his permission.
That is my understanding.
Everybody getting that? We've got the removal of life support at Dallas Children's, for which Mr. Roberson, her father, who rushed her to the emergency room in Palestine, was given no say and no permission. Correct?
Correct. Since we're on the topic, I'm sorry.
Yeah, no, since we're on the topic.
Since we're on the topic of outrageous things, I wanted to briefly just follow up on some of the committee's questioning and the testimony about sexual assault allegations against Robert Roberson. A nurse at Palestine Regional Hospital who testified that she was a certified sexual assault nurse examiner when it turns out that she was not a certified sexual assault nurse examiner, examined Nikki while she was in this grave condition, and said that she saw 3 tiny tears, anal tears. The child abuse expert at Dallas Children's Hospital who examined Nikki said that she also saw a tiny tear, but that expert, Janet Squires, said that in her opinion, that was a neutral finding. That was not evidence of abuse. In fact, she testified that any mother would know that a child with diarrhea, vomiting, diarrhea, but diarrhea is really important, or just diaper rash, to have that type of little skin tag, as she described it, is not evidence of sexual abuse. But at trial, not only was the uncertified nurse, sexual assault nurse examiner, permitted to testify that she saw sexual abuse on Nikki, she was allowed to testify about why pedophiles might choose anal penetration. This is what the jury heard. Why a pedophile with Mr. Roberson sitting right there, equating him with being a pedophile. And then when Janet Squires,
Mr. Tolson?
yes, I'm sorry.
Representative Harrison?
Thank you. Just a very quick clarifying thing. 'Cause
Sure.
I think you glossed over something that if I understand the record and your testimony is, I think, important for people to hear. You said uncertified nurse. My understanding from the review of the record is that on direct examination, this nurse made a representation that she was SANE certified, and then on cross had to admit that she had lied to the jury about her credentials to even be speaking about such a matter. Can you comment on that, and is my understanding consistent with the facts as you understand them?
You're absolutely correct, Representative Harrison. She testified on direct that she was a certified sexual assault nurse examiner, and then she admitted on cross-examination that she had never been certified.
It's just unreal.
Janet Squires was asked by the prosecutor about the anal tear. And after she gave her testimony that any parent, any mother looking at that would recognize that as essentially normal, and obviously we know that Nikki had diarrhea, the prosecutor then said, however, Dr. Squires, you've seen a lot of child sexual abuse cases, and I'm paraphrasing, and there are cases where children have been sexually abused when there's no evidence of sexual abuse. Now, this is a jury, this is a jury that was told during voir dire, and I grew up in New York State. I live in Washington, D.C. I know I'm mispronouncing this term. I know I'm not even going to try to pronounce it. Voir dire. I'm sorry.
Voir dire.
There. Yeah. My colleagues probably would have advised me not to attempt that. Every juror was asked about whether they could be fair when they heard evidence about sexual abuse. Robert Roberson being, having alleged to have sexually abused his daughter.
What's the timing of this?
During the trial, every juror, every single one, I think, back in 2003. They heard evidence about it in the opening statement. Then they heard this testimony.
So, I'm sorry, during juror selection, during voir dire.
During jury selection, yes, sorry. The phase of the trial that I won't try to pronounce again. And then, as you've heard, the allegation of sexual abuse was a grounds for the death penalty. That's how it was presented to the jury at the beginning of the trial, that there were two reasons that Robert Roberson was eligible for the death penalty. One was because he had been alleged to have murdered a child under 6, and the second was based on the sexual assault grounds. Then, after the evidence was in, the prosecutor withdrew the grounds involving sexual abuse, but they still argued that there had been sexual abuse committed by Robert Roberson to the jury in the closing argument. And I'll just say one other thing on this. Before the trial began, the trial judge overruled an objection from the defense about the admissibility of the sexual assault evidence. But the trial judge said to the prosecution, you need to, and again, I'm paraphrasing, you need to tread carefully, because if you don't prove this allegation, it's grounds for a mistrial. But no mistrial was granted. So,
Can you say that again?
Yeah. The judge warned.
At what point?
Prior to the beginning of the trial, prior to the presentation of the evidence, the judge warned the prosecution that if they weren't able to prove that sexual assault had occurred, sexual abuse had occurred, then that would be grounds for a mistrial.
And then did the defense counsel move later?
Yeah.
I believe so. Ms. Swen knows the record way better than I do. I know, I've read the record, but it's late, and I don't want to misspeak. I believe so, but she will correct me if I'm wrong.
Representative Schatzline.
So I just got to understand this, because that's a detail that I did not realize. So you're saying that as jurors were being selected, sexual abuse was mentioned. And then when this was shown to be unsubstantiated, there's no evidence of sexual abuse, and the judge even warned, hey, you cannot use this unless you have the evidence or it's grounds for a mistrial. Then in the closing statements, it was said again, and yet a mistrial was not granted. Am I hearing that correctly?
Essentially correct. I don't remember at what point the request for a mistrial was made, but sexual assault was definitely discussed during the closing argument by the prosecutor after withdrawing it as a grounds for the capital conviction.
So not only was this conviction based off of, junk science, but the jury is hearing after it's exposed to the idea that sexual abuse is going to be discussed. It's then hearing, this has been removed, and then said again in the closing argument, and we're expecting this jury, with no evidence of any of her medical history, to be able to make a decision based off of not just junk science, but really false testimony at that point.
I don't disagree with you.
Thank you.
I think that's absolutely accurate.
Okay. Representative Harrison.
Thanks. Sorry, not to belabor this point, but I'm going to be honest. I have trouble, even though I've seen a lot of this in the record. I have a real hard time getting my head around this. Where did sexual abuse first become a thing in this case? Why was the child examined for that upon presentation to the hospital? Was there a suspicion? Like, where did this come from? The case.
Nikki Curtis was a child who had bruises on her. Her father had given an explanation that medical personnel did not accept. And I want to echo what others have said. At the time, that was the medical consensus. But to answer your question, that was the scenario when this nurse decided to do an examination of Nikki Curtis's anus. So presumably she suspected...
But she did that of her own volition, or what?
She did it of her own volition and then reported what she found to one of the doctors. But what led her to go from a suspicion of physical abuse to a suspicion of sexual abuse? There was no one came up and said, Robert Roberson has been, sexually assaulting children. There was no...
But this type of dialogue, and the reason I really want to pull this is being thrown around, in my opinion, recklessly and dangerously all over the internet right now, that he sexually abused and did other things to Nikki Curtis. Has there ever been a scintilla of substantiated evidence to support that claim?
Absolutely not.
Can you say that one more time?
Absolutely not.
And forgive me, you might have already mentioned this and I missed it. He was or he was not charged with sexual abuse.
Again, Ms. Swen will correct me. I believe that he was not. The jury was not asked to. He wasn't indicted on sexual abuse. I don't believe. I believe it was an aggravating factor. But again, I'm not an expert on Texas law.
We'll go to a different witness on that.
Please
But regardless, it's whether he was or he wasn't. It is unambiguously clear from your understanding of the record that from voir dire to the actual witness testimony from somebody who was exposed as lying on direct examination as to her credentials to even be able to do this, there had been, whether there was a charge or had been withdrawn, regardless, this was still discussed in closing arguments in the Robert Roberson case.
It was.
Thank you.
I wanted to talk a little bit about the shaken baby syndrome theory, and it goes by many names. It started out as whiplash shaking in the 70s, and then it became shaken baby syndrome, and there was a whole no shaking campaign to teach parents not to shake their children. And then very few doctors and biomechanical engineers started raising questions about this, about whether violent shaking could even cause these injuries. And so a new term came to light, shaking impact. And now we have another term, abusive head trauma. But the principles for all of these, whiplash, shaken baby syndrome, shaken impact syndrome, abusive head trauma, the principles are all the same. And Robert Roberson's case, his trial, was riddled and infused with not only that term, as Dr. Phil said, dozens and dozens and dozens of times, shaken baby syndrome was used in the jury selection process. I'm going to stay away from voir dire. In the jury selection process, every juror was asked about what they know about shaken baby syndrome. As you've heard, opening statement, the defense counsel conceded it was a shaken baby syndrome throughout the trial. But what's more important is that the experts used the terminology associated with this hypothesis. And I say it was a hypothesis that became medical consensus. The terms were used throughout this trial: rotational forces, shearing forces, shaking and then slamming Nikki, a child on a soft surface like a mattress. All of those terms, which are associated with shaken baby syndrome, abusive head trauma, were used by the experts in this case, Dr. Jill Urban and Dr. Janet Squires. Dr. Squires testified that, or gave an affidavit to the police even before Nikki's autopsy was done, that the medical findings fit a picture of shaken impact syndrome. That's how this case was prosecuted. There was some flinging or shaking component which resulted in subdural hemorrhaging and diffuse brain injury. There was also an area of impact in the right back of the head. That is what Janet Squires wrote in a statement that was used as part of the arrest warrant. Shearing forces, the idea that blood vessels would be stretched and ripped and causing subdural bleeding. All of those things were testified to by Janet Squires and Jill Urban. Dr. Urban repeatedly discussed in her testimony shaking impact, shearing forces, and yet when she was called to testify before the post-conviction hearing, the 11073 hearing, she said that she never called this case a shaken baby case. And technically in her autopsy report, she said that the cause of death was blunt force injury. But she also testified that shaking is blunt force. She said on February 5th, 2003, on page 79 of the transcript, shaking also falls into this definition of blunt force. And when enough, and although it doesn't seem like, shaking is not necessarily striking a child, when a child is, say, shaken hard enough, the brain is actually moving back and forth within the skull, impacting the skull itself, and that motion is enough to actually damage the brain. So Dr. Urban was telling the jury that shaking itself is blunt force. So when you heard Ms. Compton this afternoon saying that all she heard was shaking, you can understand why, even though the doctors at times said, some people call it shaking impact, whatever, sometimes there were brief references to blows. What the jury heard was what Dr. Urban said. Shaking is blunt force. And I'm not going to go through all of the references. There's just dozens of them. But to say now that this case does not involve shaking baby syndrome alone, which is what Judge Urey said in his concurring opinion, I think misses, again, what the jury heard. And I know this committee is looking at, what the standard in 11073 says now and what, it might say differently. But I'll just say this. How do you unpack or separate testimony like this from Dr. Urban to say now that the statute doesn't apply? 11073 was designed exactly for the Robert Roberson case. And although the courts are not applying it the way this committee has said it wants it to be applied, I'll just express my view. Gretchen Swen at that hearing in 2021 met the standard that this legislature set. She established that there is new science. She established that the new science is material, that it would have made a difference. She established by a preponderance of the evidence, in my view. But unfortunately, If you read the entire record in this case and read the decision of the district court judge, it's hard to square the evidentiary record that was presented to the district court judge with the opinion that was issued. Dr. Urban was asked whether she could unpack the role that shaking and blunt force or impact played in Nikki's death. Question, and then is there any way to tell, say, I believe this much of her death was caused by the shaking and this much of her death was caused by the battering that she took? No. There's no way to segregate it out? No. Question, just all those things put together killed Nikki? Yes. Again, I don't know how a statute that says if outdated medical science was used to convict someone at their trial, and you have testimony that says from the medical examiner, I can't tell you which one was more important, how it's possible to say that a person had a fair trial under this statute, that the outdated science didn't play a significant role in the defendant's conviction, and in this case, Mr. Roberson's conviction. I want to talk a little bit, just briefly, you've heard this, but Dr. Urban admitted that she did not consider any of the following information before reaching conclusions about Nikki Curtis's cause and manner of death. She didn't consider Nikki's medical history from birth, including her recent illness the week before her collapse and the drugs that she had been prescribed by her pediatrician. In fact, Dr. Urban said she didn't even know what promethazine was when she was having a conversation with defense counsel prior to trial. And during trial, she never gave any indication that she knew what promethazine was.
Yes.
I'm sorry. You're going to have to say that again.
Yeah.
You're talking about Dr. Urban,
Dr. Urban.
the medical examiner who performed the autopsy.
Correct.
She said what?
She had a toxicology report that was attached to her autopsy report, and included in her autopsy report. She said that at autopsy they drew blood, and
the part about you said she said somewhere in the transcript she didn't know what Finnegan was.
Yeah, she had a autopsy report that reported that Nikki had Finnegan or promethazine,
Right.
It was described there, in her blood at a certain concentration, 0.4 milligrams per. Now I'm getting beyond my area of expertise.
Yep. No, but I heard you say she said she did not know what that drug was.
Yep.
Is that what she said?
She did say that to defense counsel before trial when she was asked what that was. She said, I don't know what that is. And during the trial, she never testified about that at all.
So just to be very clear, the medical examiner who conducted the autopsy of Nikki Curtis testified or admitted to defense counsel that she was unfamiliar with a drug that probably a substantial number of mothers know was. Is that what I'm hearing correct?
That is correct.
Thank you.
While we're talking about promethazine, Dr. Keenan Bora, the only medical toxicologist who has provided evidence in this case, said that the level that Nikki Curtis had, 0.4 milligrams, whatever, through his calculations, was at least 8 times higher. At 10 p.m. on the night that Robert Roberson picked up Nikki from Nikki's grandmother's house. And as it's possible that if she had been given Finnegan earlier than that as her last dose, that she could have had as much as 30 times the level. That's what his report says. There are reports that the amount shown at autopsy, 0.4, is a high level, and that child fatalities have occurred at levels just 3 or 4 times that.
Yes, Representative
amount.
Schatzline.
So what you're describing right now, how does that happen? How does she get that level of dosage? Is that, the fault of the physician? How does it happen?
You're asking me to speculate, but Nikki was in the care of both Robert and her maternal grandparents. She was given double doses of Phenergan. There's no way to know whether the caregivers understood that she wasn't supposed to get both prescriptions given to her at the same time.
She was prescribed those.
She was prescribed those drugs, and we know that she had incredibly high, dangerous levels of that drug in her system when she died. And essentially, just to break it down, Dr. Bora says that he can calculate the levels she had before she arrived at Palestine Hospital, and that he says it's very likely that they contributed to her death.
Yeah, so just, removing everything else we've talked about today, that factor alone, talking about the lifelong illness that she had mixed with the pneumonia, and now we're getting a drug that halts breathing to an extent for children, and it's a dosage that is a dangerous amount prescribed by a doctor. That alone could cause death.
That is what Dr. Bora provided in his affidavit.
Thank you.
Dr. Urban,
Sorry, Representative Harrison.
Yeah, just real quick, I want to say this for a second to pick up where Representative Schatzline left off. We had a prior witness earlier today who wasn't on herself, one of the jurors. She testified that she had heard maybe something about a cough, some kind of cough medicine maybe, but it was very cursory, high level. But the level of detail you just got done describing, the possibly 8 times, possibly all the way up to 30, because again, as I understand it, the pediatrician wrote a script and the ER doc wrote a script. One was Phenergan with codeine. If he had been trying to do his job and adhere to the instructions of the physician, that could possibly explain why we were getting 2x or higher. Is it your understanding from the record, did the jury know anything about this?
No.
Thank you.
Dr. Urban also didn't have any of the Palestine Regional Emergency Room records related to Nikki's prior treatment or her treatment on the day that she entered the hospital on January 31st. She didn't have the CT scans, as you've heard, which show a single impact in the area consistent with Robert's explanation that Nikki fell off the bed. She didn't have any of the emergency transport records, which now seem to have been lost. As I said, she didn't have any information regarding promethazine, and as I said, she didn't, at least at one point, know what that drug was. She didn't have any information about the drugs that were administered to Nikki by doctors who were trying to save her life, and Dr. Bora, in his affidavit, said that some of those medications increased her heart rate, thinned her blood. Dr. Green testified to that, I'm sorry. But Dr. Bora said that some of those drugs also lowered her threshold for seizures, including promethazine. And Dr. Urban and all the doctors who testified at Robert's trial dismissed any other explanation for Nikki's condition, including the fall from her bed, as a possible explanation for what they call her injuries. And I call it her condition because really under the shaken baby syndrome hypothesis, medical findings that are associated now with a wide array of medical conditions are characterized as injuries, when, again, those conditions have to be excluded as a possible explanation, a plausible explanation according to the American Academy of Pediatrics. And the consensus paper that you heard Professor Finley talk about on Wednesday in 2018, some of the most vocal adherents to the abuse of head trauma theory have said that you have to exclude plausible explanations like pneumonia or infection. And there's the evidence of Nikki's death from pneumonia and this promethazine is not plausible. We believe, and our experts believe, that it is the explanation for why Nikki died.
Sorry, Representative Harrison.
Can I pull that real quick? Okay, because now, and you've kind of glossed over this, but it's really important, the way that shaken baby syndrome a couple decades ago, if you had the triad, shaken baby syndrome, you can presume abuse, correct?
Correct.
Okay. Whereas as opposed to now, even the adherents to it say, well, once you exclude all other plausible alternatives, then you can start, maybe thinking about shaken baby. Is that right?
That is
so
correct.
that's a 180 flip from the prevailing wisdom when Robert's case went to trial. Is that right?
That is right.
You just said something though that's very interesting. As somebody who is as thoroughly familiar with the medical record, and I haven't heard somebody say it quite as definitively as you just did. You said, in y'all's expert opinion, it's not that there are potentially multiple now plausible explanations for everything that was shown to the jury, brain swelling, retinal hemorrhaging, subdural bleeding. You believe the other explanations actually offer more explanatory power to the point where you just said it's your opinion that those were in fact the cause of death. A, did I understand you correct, and why is that your position?
Dr. Francis Green, in his affidavit, said that, in his opinion, Nikki Curtis died as a result of viral interstitial pneumonia and her acute bronchopneumonia, which is bacterial pneumonia. And Dr. Roland Auer concurs in that opinion. And Keenan Bora agrees that she had sepsis due to pneumonia, and that promethazine or Phenergan likely contributed to her death. So it's not my opinion. It's doctors who've looked at this case, new evidence, new experts. That's their opinion.
Thank you.
If I might, I'd like to talk briefly about the case that I handled in Maryland. My wife and my children tell me often that when you let me start talking about one of the innocence cases I worked on, it can go for a long time. I'm going to keep it brief. I'm going to try to discuss only the key parallels. Clarence Jones had a 3-month-old son, Colin, who was very sick from birth. Colin was rushed to the hospital by Clarence when he woke up and found Colin choking on formula. Clarence rushed Colin to the hospital. Colin spent 7 days in the hospital before he died. He had subdural hemorrhage. He had brain swelling. He had retinal hemorrhages. Like Nikki, Colin was a chronically ill child from birth. Like Nikki, Colin had chronic recurrent infections. He had been diagnosed with pneumonia at age 3 weeks. So both of these children, Nikki and Colin, were susceptible to infections and had repeated infections throughout their lives. Colin's 3 months, Nikki's 27 months. Like Nikki, Colin had a virulent infection when he collapsed and was brought to the hospital. Unlike Nikki, Colin's doctors cultured his blood sample. They grew bacteria in the sample, and they found a virulent bacteria called Staphylococcus aureus, which is deadly. Colin had pneumonia, which Dr. Green, looking at the lung tissue pathology slides, said was chronic. He found it in her throat, from her mouth down to her lungs. He found it in her lung tissue. And he found also evidence that she had acute bacterial necrotizing pneumonia, which means that her flesh was literally dying and sloughing off. And you can see it in his report, which I believe was submitted to this committee. So both these children had serious infections, fatal infections. Like Nikki, Colin had a bleeding disorder, and his hospital blood tests after his collapse, like Nikki, showed severe DIC, disseminated intravascular coagulopathy. Colin actually had a bleeding disorder that he inherited at birth from his mother, and he had several episodes throughout his life where he had serious bleeding, his short life. Like Nikki, as I said, Colin had the triad: subdural bleeding, retinal hemorrhages, and brain swelling. And he also had other eye injuries. The ophthalmologist who testified at Clarence Jones's trial said that Colin's eyes were literally filled with blood, that the retina was torn and puckered, and described injuries to Colin's eyes that ophthalmologist said he had never seen, and testified were pathognomonic, which means essentially virtually diagnostic of shaken baby syndrome. Those descriptions about how retinal hemorrhages are the key to diagnosing shaken baby syndrome, that testimony was presented at Robert Roberson's trial. Retinal hemorrhages were the thing that Janet Squires said told you really that these eyes had been shaken. That's what Janet Squires said. Like in Robert's case, Clarence Jones's defense counsel conceded that it was a shaken baby case. In fact, Clarence Jones's defense lawyer called an expert witness who conceded that Colin had been shaken. He only disputed how violent the shaking had been. Clarence Jones spent 18 years in prison for something that was not a crime. And at his innocence hearing, we brought a writ of actual innocence under Maryland's writ of actual innocence law, because Maryland doesn't have a progressive junk science law like Texas does. During that post-conviction hearing, the prosecutors, just like the revisionist history here, pointed to bleeding that was found on Colin's rib at autopsy, which had never been discussed at trial, pointed to that as evidence that Colin had been shaken. And again, in the setting of disseminated intravascular coagulation, tiny amount of blood on the rib is not evidence of abuse. And unlike Robert's case, though, after the circuit court in Maryland ruled against us on the writ of actual innocence, in the face of 6 experts who said that Colin had died of serious infection, that this was not shaken baby syndrome. Unlike Robert's case, on appeal, the Maryland appellate court reversed the circuit court and granted the writ of actual innocence. And I will point out, I know this committee is considering ways to change the statute, but the Maryland writ of actual innocence standard is essentially the standard that Judge Alcala was discussing. The standard in Maryland to grant a writ of actual innocence is a substantial or significant possibility of a different outcome at trial if the jury were to have been known about the new evidence. And the Maryland courts have defined that standard, substantial or significant possibility of a different outcome based on new evidence, as more than a mere possibility and less than a probability, so less than the preponderance standard. And with that, I'm happy to answer any questions that the committee has for me.
I know that we've had questions as we've gone along. Representative Harrison, did you? Yes, Chairman Darby.
You were here during the Judge Alcala's testimony, correct?
I was, yes.
Okay, and she outlined, I've got 6, but probably 5 suggested changes. Probable cause instead of preponderance of the evidence is what you just referred to.
That's the standard in Maryland for a writ of actual innocence.
Okay, and she suggested changing the number of judges to be able to issue a stay of execution. single Supreme Court, require funds to be granted to appoint counsel and experts to review science, add language, theory of litigation that led to the conviction would alter the outcome, and the state can waive procedural barriers. Any other items of wisdom you'd like to give the committee as we take a look at this moving into the next session?
So I wouldn't presume to tell this committee, what Texas law should be, but I do want to comment
Well,
on.
you just said it's progressive.
It is progressive.
We have a progressive junk science law, so.
Yep, you do.
Sounds like it's still flawed.
I think the committee has expressed that view. I would like to talk about the challenges that this type of litigation that we're confronted with. The procedural barriers that Justice Alcala testified about are daunting. In this case, allegations are that pneumonia was known at trial. Well, that's not accurate. The autopsy report does reference the autopsy of the lungs and says that there were neutrophils and macrophages seen. And I think the microscopic examination essentially repeated that. That was a pretty bland explanation, and absolutely the medical examiner did not diagnose pneumonia. No one diagnosed pneumonia, and yet the district court, in her opinion, said that the pneumonia was known. Those types of references form the basis for procedural barriers that lawyers like Gretchen Swen and myself and my Innocence Project colleagues confront all the time. The idea that, and actually I want to say something else. The evidence in these cases, in these innocence cases, is developed over time. Gretchen, I think, talked about this on Wednesday, but the CT scans were found in a closet in the basement in 2018. Other evidence came out about the lung pathology slides, which hadn't been provided to Ms. Swen until I think the doctors who had to travel to Palestine to look at the tissue slides were given the lung tissue slides, which formed the basis of Dr. Green's conclusion. Dr. Auer is not a lung pathologist. In these cases, they require very careful, specific expertise. So Dr. Auer looked at these tissue slides and said, yeah, that looks like pneumonia, but he is not a lung pathologist. He's a brain pathologist. He told you he has a PhD in brain injury. But the only qualified lung pathologist who looked at the tissue slides in this case is Dr. Green, and he didn't do that until after the 2021 hearing. And that is exactly what happens in these cases. They are complex. I never thought when I went to law school that I would use the doctorate part of my Juris Doctor so much in my career. But lawyers have to do that, and then they have to find the experts who help them understand the case. And the understanding, as the science is changing, the understanding about the case evolves. And these procedural defaults and, defense lawyers, it's a catch-22. If you don't raise it early enough, then it's waived. If you raised it early but you weren't able to prove it, then it's waived. So the issue of procedural defaults is especially important in cases where the medical science is the case. And so I would urge you to consider that, because this committee and the courts and the prosecutors and defense counsel and the community should want to get to the truth. And it's hard to get to the truth, and the truth sometimes comes out in fits and starts over time as you find the right people to help you understand exactly what happened. And that is what happened in this case. Dr. Green was the one who was able to tell us exactly what happened. Dr. Bora was the only medically trained medical toxicologist to look at this case, was able to explain what happened. And at the 2021 evidentiary hearing, Dr. Downs, way out of his lane, just gave very firm opinions that the promethazine was not a factor in Nikki Curtis's death. And he was way out of his lane. And yet his testimony, if I recall, was the only testimony that the district court judge affirmatively credited, if I remember correctly. But again, Ms. Swen will correct me if I'm wrong. So I don't know if I answered your question. I realize I may not have, but.
Representative Harrison.
If there's a way to do what I'm about to ask you in a concise manner, that would be
Sure.
That'd be awesome. One of the things that I'm hearing just ad nauseum right now is that in addition to you guys shouldn't question the jury. The jury heard all the evidence. You know, you guys are on Monday morning quarterbacking and whatever. We've now established, I think, beyond a shadow of a doubt, that the jury did not have all the relevant medical and scientific evidence that should have come to that courtroom. The question I have, though, is what's also said is there's been 20 years of appellate processes playing out. And so all of the new stuff that the committee has access to and the stuff you're pointing out and talking about, this has all been considered by the courts, and they all found it, insufficiently meritorious of a new trial. My understanding, if I've heard you correctly, is you've listed off multiple things, although forgive me, I didn't write them all down, so I don't want to try and screw this up. Is there any way you could even almost just like in bullet form, and I'll phrase it this way, is there any evidence that no jury and no court has interacted with or contemplated as this thing has moved through the appellate process for the last 2 decades?
Absolutely. Dr. Green's expert report has not been reviewed by any court or jury. The most recent 11073 petition that we filed, I guess 2 weeks ago or whatever, was dismissed with procedural grounds. And the one that was filed in August was dismissed on procedural grounds. So Dr. Green's report has never been considered by any
Just real quick,
court.
Dr. Green's report, which in a sentence or two, what was the import of that evidence that no court has interacted with?
Nikki Curtis died from chronic pneumonia, both viral and acute bacterial pneumonia.
That's evidence that no court nor jury has ever interacted with in over 20 years.
Correct. Dr. Bora's report, the only medical toxicologist to examine the case, concluded that Nikki's promethazine levels were dangerously high and contributed to her death. No court nor jury has considered that.
So she had drugs in her system that were potentially at a toxic or fatal dose, and no jury or court has ever interacted with or contemplated that evidence.
That's correct.
That's correct,
Mm-hmm.
Okay.
The other evidence about the change in science was presented during the 2016 to 2021 proceedings, but the district court, I'll just say that opinion did not reflect the evidentiary record that was presented to.
How substantial would you characterize the body of evidence that no court or jury has ever interacted with when taken as a whole?
Overwhelming evidence that Nikki Curtis died of natural causes, not any abuse by Robert Roberson.
So you're testifying that there is overwhelming evidence that no jury, the original trial, or at any of the phases of the appellate process for 20 years, that she died of natural causes, and they have never considered this. No courts, no jury. Is that what you are testifying to here today?
I can't speak to what judges who have affirmed the conviction in this case have reviewed, but the evidence is overwhelming, in my opinion, that Nikki Curtis died of natural causes.
And at least a significant percentage of that has never been interacted with by a jury or the courts.
Absolutely, the recent affidavits that were submitted in August have never been considered by any court. And absolutely none of this evidence that we've been talking about today, as Ms. Compton said, was considered by the jury.
So the original jury, and again, we don't like to second-guess juries here, but it is unambiguously true, no jury has heard the body of evidence you've just been describing for the last hour.
Unambiguously true.
Thank you.
Members, do we have any other questions?
Can you
Vice
speak to
Chair
the
Cook?
procedural grounds that the last two petitions were dismissed on?
So the court didn't explain the procedural grounds. They just referred to the statute, which I believe is 11071, which says that there are various procedural grounds that can bar consideration of a subsequent habeas petition, including not bringing the claims sufficiently soon enough, or having previously brought claims and having had them denied. So there's various grounds, but the court didn't specify which one of those grounds. The last several subsequent habeas petitions that were filed were dismissed on procedural grounds without any explanation.
Members, do we have any other questions? Mr. Salzman, I want to thank you for your time and your testimony. And I know that maybe possible that some of us will have some follow-up questions for you. Is that okay? You make yourself available for that?
Absolutely happy to answer any of the committee's questions at any time.
Great. And if that's okay, I think we probably have your contact information here. Is that okay that we distribute it to the members in case they want to reach out
yes.
to follow up? Thank you so much.
Absolutely.
All right.
Thank you for your time.
Thank you. Chair calls Catherine Judson.
Thank you for your time.
Thank you. Ms. Judson, can you hear me okay?
Now I can hear you. Yes, thank
Okay.
you.
No, I appreciate you. Appreciate you making yourself available today. I know it's been a long day, and so I certainly try to be respectful of everybody's time. And I know these things will continue to talk. The schedule changes as we go along, so I want to apologize for taking so long to take your testimony. But I appreciate you for being patient with us.
Oh, please don't apologize. I've been a lawyer for a long time, and waiting around is part of the job.
Yeah, I guess that is a big part of the job for us.
A lot of hurry and wait. But I'm very grateful to you for inviting me to speak with you today, and I'm especially grateful for your really, honestly, honorable efforts to seek justice in this case.
Yep. Oh, I appreciate that. Thank you. I have you registered, Catherine Judson, testifying on behalf of yourself and neutral on the topic. Is that accurate?
Yes.
Okay. I have it here that you're in Madison, Wisconsin. Is that true?
That's true.
Okay, someone was asking on the committee.
I'll talk a little bit about our geographical focus or lack thereof, and hopefully clear up why you want someone from Wisconsin to talk to you.
Yeah, that's why I mentioned. I think it's important for context purposes. But I think obviously your background and your explanation of your background and what you do, I think is going to probably clear that up fairly quickly. As you've seen with the other witnesses today, just going to invite you to make your comments on the topic that we're discussing today. Members may have questions as we go along, and so we'll jump in if we need to, and if not, we'll ask some questions at the end, if that's okay with you.
That sounds perfect. I did prepare remarks, and then, of course, I plan to make myself available for your questions.
Fantastic. Okay, well, we'll turn it over to you. Thank you.
Okay. Well, you've heard a lot of testimony today, so I'm going to do my best not to repeat any of that, but instead to give you context for Robert Roberson's case based on my work on shaken baby syndrome cases across the country and actually around the world, and also to place into context some of the arguments and responses you've heard both about SBS AHT generally and then this case specifically. So hopefully be able to clear all of that up. I want to tell you a little bit about my background and then the organization I work for. I'm the executive director of the Center for Integrity in Forensic Sciences. We are a nonprofit organization exclusively devoted to ensuring that scientific evidence presented in courts is valid and reliable. We are headquartered in Madison, Wisconsin, but our service is not based on geography. We have consulted on cases involving forensic sciences in most states in the United States, as well as in multiple countries. At our center, we have expertise in a lot of other types of cases other than child abuse, but we are recognized as experts in child abuse cases. We've also weighed in on DNA issues, many other forensic errors, and much like the Innocence Project, there's a process in order to get our help. There has to be a serious error in the forensic evidence, and we really take very few of the cases referred to us. But this one cried out to us. So for that reason, our organization has filed 3 amicus briefs in Robert's case and completed a thorough analysis of his case. We filed those when the case was pending with the Anderson County Trial Court, then when it went to the Court of Criminal Appeals in 2022, and finally supporting certiorari and relief at the Supreme Court of the United States level. As an attorney, my personal experience with this issue started with my first SBS case, which was a first-degree murder trial tried in 2010. And since then, I have provided mostly post-conviction review services, providing direct representation in cases and also consulting services. I don't think that there is an office out there that has touched more shaken baby syndrome cases than we have. And I say that not to toot our own horn, but because I think it's important that you understand why I feel able to give you this broad perspective. I also served as the Innocence Network's shaken baby syndrome litigation coordinator from 2012 to 2014. Then I did the same job at the Wisconsin Innocence Project at the University of Wisconsin Law School until 2019 when I came here to our center. During that time and currently, I consult probably on about 100 to 200 shaken baby syndrome cases per year, although that does vary. I've been published on the topic in law reviews, proceedings of the American Academy of Forensic Sciences, the American Bar Association, and so on. And I have spoken before lots of groups, including the prosecution and defense organizations, universities, and the National Academies of Science about forensic science and the law. I've served as an expert witness on the topic of ineffective assistance of counsel in forensic cases, and I also teach law school at the University of Wisconsin. So I want to tell you a little bit about forensic science versus real science and the trajectory of forensic science reform. That movement, as we understand it today, really started around 2009 when the National Academies of Science drew a distinction in their report, Forensic Science in the United States, A Path Forward, between real science and forensic science. They found that the forensic sciences used in courts are largely not scientific, and after a thorough review, they found that only nuclear DNA analysis was shown to be able to match a piece of evidence with an individual with a high degree of reliability. Then the President's Council of Advisors on Science and Technology followed up on that in 2016, outlining issues with the state of forensic science. And although they did not address it in detail in 2016, they specifically mentioned shaken baby syndrome as one of the concerns that they had moving forward that needed urgent attention. One of the concerns that both bodies raised in the development of forensic science disciplines was that they were developed with an eye toward law enforcement rather than pure scientific inquiry. So I'll give you 2 specific examples that I hope will resonate. The first is, I hope specifically in Texas this resonates, that the review of bite mark cases in the United States. After DNA showed definitively that bite mark comparisons could be wrong, and further studies showed that bite mark matching isn't reliable, and the President's Council of Advisors on on Science and Technology and the National Academies of Science did not find this discipline to be reliable. We started to see it being used somewhat less in courts and being challenged more, but also seeing some of the changes that are occurring in shaken baby syndrome cases to try to get out from under the scientific challenges. So I'm foreshadowing this for you, but I'll explain it in a few moments. Then in around 2015, 2016, the FBI found that, well, hair comparison analysis was shown to be flawed during that time. And then the FBI worked with the National Association of Criminal Defense Lawyers and the Innocence Project to review cases with hair comparison analysis. In most of those cases, in fact, almost all of them, analysts testified beyond what the science could support and with more certainty than the science offered. And that's really important because those are factors that have led to unjust outcomes in lots of other types of cases, including shaken baby syndrome. And those specific errors are, first, that unsubstantiated information is presented as fact, right? So in a hair comparison case, it would be that examiners have a high degree of reliability in differentiating two different hairs under the microscope. And then the second error is overstating the evidence. So perhaps telling a jury that an examiner is never wrong, that their error rate is 0. This is a persistent theme throughout all of the forensic science disciplines. In fact, about a quarter of all exonerations involve bad forensic science. And in most of those cases, there are overstatements or false statements by examiners or analysts, experts, however they're styled. Another great example, and one that should be familiar to folks in Texas looking at death penalty cases, is arson. Arson is a good forensic science to compare to shaken baby syndrome because an expert's opinion in an arson case, as an SBS, is the basis for a charge and often a conviction. But arson has been treated a little differently by our courts, which I'll explain. So like shaken baby syndrome, arson used to be what essentially amounts to a diagnosis of exclusion. The term used in that community was negative corpus. That means that when you rule out all of the other possible causes of a fire, then you can settle on arson. But we now know that the signs used to do that are wrong, and the negative corpus procedure is fraught with error. So just like in SBS cases, signs that were previously used to determine arson could possibly be present in an arson case, just like signs previously used to determine abuse could possibly be present in a child abuse case. But they're also present for lots of other reasons. But unfortunately, in arson cases and also in child abuse cases, experts claimed that they were reliable indicators of the crime. Right? And so given what we now know with scientific experimentation and a really careful look at arson science and fire science, we know that we can no longer look at those signs and say that something is arson without more information.